let's change it up. Let's go down to Georgia. This is the all-purpose calendar with Judge Eric Morrow. Still waiting for some other courts to come online.
What will be the truth, the whole truth, and nothing but the truth? Thank you. You can place your hand down. Yes, Ms. Spear.
Yes, Your Honor. This is Malcolm Wilson, position 64 on today's calendar. On count one, the state is recommending 12 months served, 34 days, credit for any time already served, balance probated. Stay away from the Goodwill at 1155 Mount Vernon Highway in Sandy Springs, 40 hours of community service. On count two, the obstruction, 12 months probation to run concurrent to count one and the statutory $300 fine. In count three, the false info to a law enforcement officer will be 12 months concurrent to count one. We do ask that defense stipulate to ID, venue, and factual basis for the plea. Thank you.
Mr. Dodd.
We stipulate for purposes of the plea, Judge. My client has been in custody 17 days, which will mean time served. He does have a Clayton County hold, Judge, so as soon as we're done, Clayton will come pick him up. I would request the court to consider a non-reporting probation upon completion of the conditions, Judge.
Okay, Mr. Wilson, it's my understanding that in case 26 CR 000102F, you wish to plead guilty to loitering and prowling, willful obstruction of law enforcement officers, and giving false information to law enforcement. Is that correct?
That is correct. Would be a discrepancy if I was to plead NOLO?
Has a NOLO plea been discussed, Mr. Dodd?
No, Judge, I literally just met with him this morning and he just mentioned that he wished a NOLO plea. And I apologize, Judge. I should have asked. I don't know if he's eligible right offhand, Judge.
It's not, it's okay. I'll still take it.
Okay, do we have anyone, Mr. Howard?
Your Honor, we'll withdraw that request, Judge. He's going to proceed with a guilty plea.
Sure.
Okay. So it's my, again, it's my understanding that you wish to plead guilty to these three charges. Is that right?
That's correct, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Wilson. When you complete the terms, I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you, Judge.
Mr. Wilson. I appreciate it.
Item 58, Mr. White, Willie White.
Well, the next contestant comes up. Ronnie, thank you for becoming a channel member. Welcome. You've just joined the best community in law to bar none, and I don't just say that because it's the channel I run. These people are just wonderful. So you have access to the pre-show now. That starts a half an hour before this show, and you'll see that come up in your feed. As well, you have the ability to call in and talk to me in the fourth hour. To do that, make sure, if you're not already on our Discord, which I'm sure Barbara's about to drop a link to, that you join us on Discord, and make sure that your YouTube login, your YouTube account is linked to Discord, and then that gives you access to the member area where every day I post the link to be able to join me in the fourth hour. So again, welcome.
In East Point, we also request that defense stipulate to ID, venue, and factual basis for the plea. Thank you.
Mr. Dodd?
Your Honor, we stipulate for purposes of the plea, this would be a time served sentence based on my calculation. He has served 18 days. I would ask the court to consider waiving the first 2 months of probation fees and perhaps non-reporting upon completion, Judge, of the conditions.
Does Mr. White need assistance with housing?
He does, Judge. I believe, I haven't confirmed it yet. We spoke, social workers spoke to him initially, but I'm going to have them talk to him today, Judge.
Okay, thank you. Mr. White, it's my understanding that in case 26 CR 000100A, you wish to plead guilty to criminal trespass. Is that correct? He has his hand up there, Mr. Dodd.
Yes, sir.
You don't have to.
Oh, okay. I didn't know if you had a question. Um, are you under the influence of any drugs or alcohol this morning?
I can't remember.
Are you
Oh,
currently right
oh,
now?
no.
You've been represented by Mr. Haddad there. Are you happy with what he's done for you?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that because you're pleading guilty to it, you're giving up that right?
Yeah.
Has anyone forced you to plead guilty? I'll accept the plea as negotiated. I will waive 6 months of the probation fees to help him get on his feet. I do want him to have a social worker visit to assist him with any housing requirements. When he completes the terms, I'll have it go to a non-reporting status. Good luck to you, Mr. White.
Thank you, Judge.
So, will I be getting out of jail today?
You should be.
You didn't hear me?
Oh, yeah. So I'm not sure what else you have to do today, Mr. White. I believe you're finished with my court. So if you have some other charges that are pending, I take it that's what this is, Mr. Dodd. Is that right? No?
Judge, he does not have any other holds, so what I told him
Okay.
is it'll take him until tonight or possibly tomorrow morning to process him out, but he should be released after this case.
Okay. All right. So you have the answer to your question, Mr. White?
Yes, sir.
All right. Good luck to you, sir.
Thank you, Judge.
You're welcome.
Or Mr. Watson?
Your Honor, I believe that's Ms. McLeod.
Ms. McLeod, are you with us? You might have stepped away for a moment. Can we
Your
go?
Honor, I'm here. I'm sorry.
No, you're fine, Miss.
I was
Ms.
having
McLeod.
difficulty unmuting. I am here.
This is Mr. Watson, position number 54. What are we doing with him this morning?
Mr. Watson?
Yes.
Your Honor, he's just listed as conflict. I'm not sure. if
He's
any
not my client, Your Honor.
signed yet.
Yes, I am.
Okay, you've talked with Miss McLeod before, Mr. Watson?
That's in my last court. That was, I think that was you.
Your Honor,
Okay.
I think I pulled that information from first appearance, Judge, when I looked at the calendar. I'm not sure who the attorney was, the conflict attorney, but it was noted there was a conflict case, Judge.
Okay, well, can we have you handle that case, Miss McLeod? Is that possible?
I could not handle it this morning, Your Honor, because I have 5 clients on this morning, and I went to the jail yesterday and spoke to all of them. So I didn't know about him, and I actually have another matter in DeKalb County. So I was asking that all my clients. That's why I went to speak to all of them from yesterday, so I would know what they were doing.
Okay. So Miss Spear, I see that the state is requesting 120 days. Do you have any idea of how many days? Is this a time served plea or not? Do you know?
It would not be, Your Honor, no.
Okay, so Mr. Watson, given that it's not a time served plea, I'm going to reschedule your case for next Tuesday, which I believe is the 27th. And Ms. McLeod, if you wouldn't mind handling that for the court next week, is that possible?
That is possible, Your Honor.
Okay, so Mr. Watson, I'm going to see you back next Tuesday.
All right. Number 55, Mr. White, Devin White.
And this is also your case, Ms. McLeod?
This is my client, Your Honor, and this is going to be a negotiated plea this morning.
Good morning, Mr. White. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Thank you. You can place your hand down. Yes, Ms. Spear.
Yes, the state's requesting 12 months, served 32 days with credit for any time already served, balance probated. FVIP, no further contact with the victim, Jeanette Pullins. Stay away from the apartment complex at 3215 Cushman Circle in Atlanta. 40 hours of community service and no firearms as a result of this plea. Count 2 will merge with count 1. Thank you.
Ms. McLeod?
Yes, Your Honor. My client asked me to raise with the court the issue of no further contact because they are engaged and it was a dual arrest situation. Both of them were arrested. And she had indicated at the time of the arrest that she wanted to have contact with him. They had both indicated that, Your Honor.
Okay. Ms. Jeanette Pullins is with us. Now is your opportunity to address the court. Has your office had any contact with Ms. Pullins, Ms. Spear?
I was just looking it up.
And did you have to, I take it that you didn't have any direct contact with Ms. Pullins, Ms. McLeod?
Did not, Your Honor. I was not able to get her on the phone.
Okay.
It was, I can
But
confirm it
at
was
the
a dual
time,
arrest, but no, we haven't had any contact with her.
Okay, so until there's contact with Ms. Pullins, I will have no further contact. If she has a different request in the future, she can or he can petition the court to modify that portion of the sentence. Is he still
thank
with
you, Your
today?
Honor. I will do that.
Okay, very good. If nothing further, Mr. White, it's my understanding that in case 26 CR 0000119C, you wish to plead guilty to battery family violence. Is that correct?
Yes, sir, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. White. When you complete the terms of the probation, I'll have it go to a non-reporting status.
Okay.
Right.
I do. I did bond out on this charge like a couple of days ago. I don't know why they haven't let me out yet though.
Okay, well, given that you've entered into a plea agreement today, you'll be released if you don't have anything else holding you as soon as the jail can process you out.
All right, thank you.
Yes, sir. Good luck to you.
Thank you, Your Honor.
Once again, good morning, everybody. Happy Tuesday. Welcome to TCF Live. I hope you all had a good extended weekend and you're raring to go for a Tuesday here. Let's go up to Michigan, Otsego County, where justice is best done in. It's like a Monday here, where justice is best done in a converted pole barn. There we go. Judge George Mertz.
And then let's see here. Mr. Gallagher, 1 second. Mr. Gallagher, are you able to hear me okay?
Yes, Your Honor.
Okay. So let's go on the record in People versus Anthony Gallagher. This is file number 256872. The record should reflect Mr. Gallagher is present today by video from Otsego County Jail. If I could have counsel put your appearance.
Morning, Your Honor. For the record, my name is Teachel.
Thank you, Your Honor. Richard Trush, on behalf of Mr. Gallagher.
Mr. Trush, can you tell me the status of this file here today?
Yes, Your Honor. We have a agreement that we intend to enter into today to resolve the matter. Mr. Gallagher would plan to count 1, count 2, and the enhancements would be dismissed.
Mr. Roll, is that a correct statement of the plea offer?
It is, Judge.
All right, Mr. Gallagher, were you able to hear that?
Yes, Your Honor.
Is that the plea agreement that you've discussed with your attorney?
Yes, Your Honor.
And did you want to go forward with that plea agreement today?
Yes.
You raise your right hand, please. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Mr. Gallagher, are you currently on any kind of probation or parole?
No, sir.
You understand that by pleading guilty to count 1, which is possession of methamphetamine, that the maximum possible penalty that you could face would be up to 10 years and or a $15,000 fine. Do you understand that?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at a trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself at a trial if you wanted. Do you understand all those rights?
Yes, sir.
And do you understand that you're giving up and waiving all of those rights by pleading guilty today?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you can only do that by leave. And that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here on the record today?
No, they have not.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty to this charge because you are actually guilty?
Yes, Your Honor.
The information I have indicates that this happened about a year ago on January 17th of 2025. Is that the correct time frame?
Yes, Your Honor.
At that time, were you present here in Otsego County?
Yes.
While you were here in Otsego County, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time?
No, I did not.
Mr. Roller, are the people satisfied with the factual basis?
Yes, Judge.
Mr. Trush?
Defense is satisfied.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
I'm aware of none, Your Honor.
And are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Defense is satisfied.
Thank you. Mr. Gallagher, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. Between now and then, you'll be meeting with someone from the probation department for a pre-sentence report. And you'll have an opportunity to review that with your attorney prior to the sentencing hearing. Mr. Trush, is there anything else we need to address on this file today?
Not on this file.
Mr. Rolla?
Thank you.
Mr. Gallagher, do you have any questions about how we're going to proceed with your case?
No, I don't, Your Honor.
Okay, thank you. That's all for this hearing today, and the court is going to disconnect.
Thank you. Have
All right, Mr. Burke, we're still waiting for Mr. Dion's counsel. We have a bit of a snowstorm up here overnight and into the morning, so she's running late, so we'll get started with your case as soon as we can.
No problem, Your Honor. Sounds good. Thank you. Appreciate that.
Mr. Trush, did you have Mr. Drysdale?
I do. Is he logged into Zoom? The court had previously approved his Zoom appearance.
You see that, but I don't see him, so we'll just pass that for the moment. Sir, are you Alan Millsap?
Yes, can you hear me?
I can, thank you. All right, we're gonna go on the record in People versus Millsap, and this is file number 256912. The record should reflect Mr. Millsap is present today by video from Department of Corrections. Mr. Millsap, the court set this for a hearing today because we have a jury trial scheduled in your case for March. And we received some information that your attorney, Mr. Mataloni, passed away in December. Is that your understanding as well?
That's correct.
So I scheduled this hearing because I wanted to see where you were at in terms of counsel, if you were, planning on hiring your own counsel, if you wanted to request court-appointed counsel. Can you tell me where things are at from that standpoint?
Yeah, I have two new lawyers, Marcus Baldori and Robert Baldori.
Okay. And do you know, are they going to file appearances in the case? Because we haven't gotten that yet.
Yes.
All right. And is it going to be your intention to have them proceed with that trial as scheduled in March, or do you know if they're going to be wanting more time since they're coming onto the case at this point?
It's my understanding that most likely they're going to want that to change so they have time to prepare.
Okay. All right. Thank you. Mr. Rolla, was there anything that you wanted to add for the record?
Judge, I was just indicating we haven't received any appearances yet either, but should they file them, obviously with them coming in, people aren't gonna have an objection if they make a motion.
Okay. So Mr. Millsap, if you do talk to your attorneys, they need to file an appearance in the case so that we can start sending them mailings and so that they have access to all the filings. Once they do file an appearance, then the court will set this for another status conference. Hopefully that'll be, within the next 30 days or so. And then I'm going to leave that trial date on for now, but certainly if your attorneys request an adjournment and you don't have an objection, it sounds like the prosecutor won't, then that's something we can address later. Do you have any questions about that?
Yeah, I do not.
Okay. All right, thank you. That's all for this hearing today, and the court is going to disconnect.
It's TCF Live on a Tuesday, a quiet Tuesday out there, to be honest. Not a whole lot of court action at the moment, but it should pop off eventually. Sometimes coming out of a longer weekend, things are a little slower to start. But let's rotate back to Georgia and continue with Judge Morrow for a little bit.
It's Wilkie right here, positions 35 and 38.
And what are we doing with Miss Miles Wilkie this morning, Ms. McLeod?
Your Honor, we are requesting that all of her cases be placed on the next available jail trial calendar.
And so you'll file a waiver in the matter?
Yes, we've already filed waivers into all the cases.
Okay, very good. Good morning, Ms. Miles Wilkie. Your case will be returned to the division judge and you'll get notification of your next hearing date, ma'am. Good luck to you.
I also have Ms. Lupo right here, position 27. She's also Ms. McLeod.
Your Honor, Ms. Lupo is going to be a negotiated plea.
Yes, good morning, Ms. Lupo. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, I can't hear you. You're gonna have to scooch up for me or speak up. Okay, you can place your hand down. Thank you, ma'am. Yes, Ms. Speaker.
States negotiated 12 months probation, 30 days to serve with credit for any time already served. Stay away from all 5 below stores, especially the one located at 3612 Marketplace. That's the incident location. No further contact with the co-defendant Sakai Sekayyi, Thomas, MH /BHET. We do ask defense stipulate to ID venue and factual basis for the plea. Thank you.
We do so stipulate.
Ms. Lupo, it's my understanding that in case 26 CR 0000115Y, you wish to plead guilty to theft by shoplifting. Is that correct? Say it again for me, please.
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right? Say it again.
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Lupo. When you complete the terms, I'll have it go to a non-reporting status. Good luck to you, ma'am.
Let's head slightly more south. Wade Mercer is starting his first appearances.
Mr. Chubb, and make sure he can hear you, please.
Señor Chop, mi nombre es Jordani Ricardo. Soy intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí.
He can hear me and see me, Your Honor.
Great. Mr. Chubb, you're back to first appearance this morning for the no valid driver's license charge. I saw you about this weekend.
Señor Chop, está de nuevo frente al tribunal por el cargo de no tener licencia de conducir, por el cual yo lo vi este fin de semana.
I'm appointing Mr. McDaniel's office to represent you and asking that you listen to your attorney.
Le voy a asignar a la oficina del señor McDaniel para que lo represente y le pido que escuche a su abogado.
Your Honor, I spoke to Mr. Chubb. He's going to plead no contest to the charges listed.
Su señoría, hablé con el señor Chop. Él se va a declarar no me opongo de los cargos, así como se le acusa.
Understanding he'll serve 10 days in the county jail. He'll have 3 days jail credit, be a $400 fine.
Entendiendo que tendría que cumplir 10 días en la cárcel, tiene crédito por 3 días y tendría una multa de $400.
It's been explained that any conviction can result in deportation and that there's already an ICE hold for him as well.
Le he explicado que cualquier tipo de condena puede resultar en la deportación y que él ya tiene una orden de parte de retención de parte de inmigración.
Signed his plea waiver form with his right to jury trial and call witnesses.
Él ha firmado la hoja renunciando a su derecho a un juicio y a llamar a testigos.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Gracias, señor Mitchell. ¿Está de acuerdo el Estado? Lo está su señoría.
And Mr. Chubb, did you hear that agreement?
Señor Chop, ¿escuchó usted el acuerdo? Yes.
Mr. Chubb, do you have any questions about that agreement?
Señor Chop, ¿tiene alguna pregunta acerca del acuerdo?
Oh,
No.
Is that the plea that you would like to enter?
¿Es ese el acuerdo que usted desea aceptar?
Sí.
Yes.
Mr. Chubb, I'm going to accept your plea of no contest to the charge of no valid driver's license.
Señor Chop, acepto su contestación de no me opongo ante el cargo de no tener licencia de conducir válida.
Adjudicate you guilty of that offense and sentence you to 10 days in the Jackson County Jail.
Lo voy a condenar culpable de la ofensa y lo condeno a 10 días en la cárcel del condado Jackson.
Mr. Chubb, you have credit for the 3 days you've already served.
Señor Chop, tiene crédito por los 3 días que ya cumplió.
And I've got to impose the fine set by state and county law, which is $400. That'll be a civil judgment.
Y le tengo que imponer la ley fijada por la ley del estado y del condado. Son $400 de multa.
Mr. Chubb, the jail will go ahead and notify immigration that you can be picked up at any time.
Señor Chop, en la cárcel le notificará a inmigración que ya lo pueden recoger en cualquier momento.
So you'll actually finish this sentence while you're in their custody, most likely.
So, lo más probable es que seguramente usted terminará esta condena mientras esté ya bajo la custodia de ellos.
Do you have any questions?
¿Tiene alguna pregunta?
No.
No.
Have a good day, sir.
Que tenga buen día, señor.
We have Alvarado, and Mr. Ricardo, if you'd please introduce yourself to Mr. Alvarado and make sure he can see and hear you.
Señor Alvarado, soy Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí.
He can hear me and see me, Your Honor.
So, Corporal, I've got his name spelled differently. On the jail sheet, the interpreter request from the jail and the complaint don't match. So, Corporal, looks like it may be an error at the jail. Can you check the spelling of his name? Is it Alvarado or Alvardo, Corporal?
Alvarado.
Sir, can you spell your last name?
Señor, ¿me puede deletrear su apellido?
Alvarado.
Yeah, they missed an A.
Okay. So, Corporal, if we get those jail records correct, Mr. Alvarado, I'm going to appoint the public defender's office to represent you and ask that you listen to your attorney, sir.
Señor Alvarado, le voy a asignar a la oficina del abogado de oficio para que lo represente y le pido que escuche a su abogado.
Your Honor, I spoke to Mr. Alvarado. He's going to plead no contest to the charge as listed. The understanding he'll be sentenced to 10 days in the county jail with 3 days jail credit.
Su señoría ha hablado con el señor Alvarado. Él se va a declarar no me opongo ante los cargos, así como se le acusa, entendiendo que se le va a condenar a 10 días en la cárcel con 3 días de crédito.
Be a $400 fine imposed, which would be a civil judgment more than likely. He has waived his right to a jury trial and call witnesses and understands that any conviction can result in deportation.
Él también tendrá una multa de $400, que lo que más probable sea un fallo civil. Él ha renunciado a su derecho a un juicio con un jurado y entiende que cualquier tipo de condena puede resultar en la deportación.
Nothing else, Your Honor.
Es todo, su señoría.
Thank you. And Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? Lo está, su señoría.
Mr. Alvarado, did you hear that agreement, sir?
Señor Alvarado, ¿escuchó usted el acuerdo?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
No.
Did he say
no?
He said no. And is this the plea you would like to enter, sir?
¿Es este el acuerdo que desea aceptar, señor?
Pues no puedo solicitar una fianza, creo, ya no sé.
Well, I'm not able to request a bond, right? I don't know.
You already have a bond on the driving offense, but you do not have a bond. You're not entitled to the one on the immigration hold.
Usted ya tiene una fianza por el delito de conducir, pero no tiene derecho a una fianza en la retención de parte de inmigración.
I explained to you this weekend through an interpreter that if you post bond on the driving offense, you still will not get out of jail because of the immigration hold.
Yo le expliqué este fin de semana mediante un intérprete que aunque usted pagara la fianza, en el caso de manejar, no saldría de la cárcel como quiera debido a la retención de parte de inmigración.
So do you want to enter this plea or not?
Entonces, ¿desea aceptar este acuerdo o no?
Sí.
Yes.
Want to accept your plea of no contest to the charge of driving with no valid driver's license.
Acepto su contestación de no me opongo ante el cargo de manejar sin licencia de conducir.
I'm going to judge you guilty of that offense and sentence you to 10 days in the county jail.
Lo condeno culpable de la ofensa y lo condeno a 10 días en la cárcel del condado.
I'm imposing the fine of $400 and giving you 3 days credit.
Le impongo la multa de $400 y le doy 3 días de crédito.
And I'm going to ask the jail to notify ICE to pick you up so you may actually finish this sentence while you're in their custody.
Y le voy a notificar a la cárcel que le avise a inmigración que lo pueden recoger, así que quizás termine esta condena bajo la custodia de ellos.
Do you have any questions?
¿Tiene alguna
No.
pregunta? No.
Have a good day, sir.
Que tenga buen día.
Thank you, Mr. Carter.
Thank you, Your Honor.
Next case is Dennis Howard. I'm sorry, it's Howard Dennis. I apologize. Mr. Dennis, good morning. Mr. Dennis, you're here for first appearance accused. Good morning. You're accused of one count of obstruction of justice, Mr. Dennis. I received a call from the captain at the Sheriff's Department this morning advising us that they think that additional felony charges are very likely, depending on what happens today. So I'm just making you aware of that possibility. As far as this charge, there is probable cause, and I'm going to appoint the public defender's officer to represent you for first appearance purposes. Mr. Dennis, let me see what Mr. McDaniel's position is and Mr. Mitchell's, and then we'll go from there. Mr. McDaniel, anything?
Your Honor, we just asked for some kind of reasonable bond. He lives around here. He's not going nowhere. I've already talked to him about he needs to bond out so we can go talk to the attorney ASAP as soon as possible, and you know, whatever kind of legal actions that might be coming.
Okay, so the confusion on the name is the jail sheet says Howard Dennis in one place, and the other place it says Dennis Howard on the pretrial release sheet. Which is correct, sir?
I think it's William.
My name is William Howard Dennis.
William Howard Dennis is his name,
So Corporal, the pretrial release sheet is the opposite of the other paperwork. So it's William Howard Dennis. Okay, so Mr. Dennis, thank you. Mr. Dennis, the pretrial release sheet is not filled out. So I have no idea if you're employed. I have no idea if you're retired. What's your employment status?
I am employed. I'm employed with Beard Equipment Company in Panama City, Florida. I work every day. I pay mortgage. I'm trying to do it all.
How long have you had that job?
I've had that job for about 9 months when I moved from another equipment job in Panama City to there.
Okay, and how long have you lived in Jackson County?
I'm born and raised here.
Okay. Mr. Mitchell, anything from the state?
No, Your Honor.
Mr. Howard, I'm going to set you the standard bond of $2,500. Now, whether you go ahead and post that bond or whether you wait to see if there's other charges is up to you. I was just advised there's likely to be additional charges coming, but we'll see what happens. You have the right to post the bond immediately and be released. You do need to understand that this bond has nothing to do with any other bond. If they charge you with serious felony charges like they're discussing, that would be a totally separate bond, probably much higher than this. You need to be aware of that possibility. But right now, that's your bond, $2,500 cash or surety. It's a pretty standard bond for this charge. You might be a conditional release candidate. The problem is these other charges that's kind of throwing a kink in everything. So hopefully they'll know the next day or two if there's going to be additional charges or not. Do you have any questions?
All right, sure.
All right. Have a good day, sir. We had some individuals just come in for first appearance, I think. Are y'all here for a first appearance case?
Court date, February 2nd, 9 o'clock.
Please, February 2nd, 9 o'clock. What's his name, ma'am? I'll try to call it next. Richard Glass. We have parents here on Richard Glass, so let me see him next, please. Mr. Glass, your mom and dad, stepdad?
Uncle.
Okay, your mom and your uncle are in the courtroom, Mr. Glass. You're here because you've been accused of one count of possession of methamphetamine and one count of resisting an officer without violence, Mr. Glass. There is probable cause for the charges, and Mr. Glass, I think you're entitled. I think you're entitled to a bond, Mr. Glass. Let me see if the attorneys have an additional thing to add before I set that bond. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell.
We just request to be subject to random UAs.
Thank you. Mr. Glass, I'm going to set you the bond of $5,000 on the felony charge and the bond of $2,500 on the misdemeanor. I have read your criminal history. I've also looked at your driving record and see some recent stuff as recently as within the last month, some driving with no registration or something like that that's still pending. So, Mr. Glass, your total bond is $7,500 cash or surety. Cash or surety means he can either put up all of it if he wants to and has the ability to, or he can go through a bondsman. That's what a surety bond is. His bond has a condition of random urinalysis. Because it's a drug offense, ma'am, that means that he can be given a drug test. And if he tests positive for anything in his system that he doesn't have a valid prescription for, he could go to jail with no bond. So that's a condition of his bond. Let me see if your mom has any questions. Let me see if your mom has any questions first, Mr. Glass. Then we'll see if you have any questions. Ma'am, do you have any questions? No. Mr. Glass, do you have any questions?
No, sir. You can test me right now. I'm clean.
All right. Well, you'll get a chance to use the phone in just a few minutes, ma'am, and whether y'all post bond or not, it's up to you. He's also going to be giving his notice for his next court date. Would that be the 3rd, February 3rd at 8:30 will be your court date. They're going to give you that notice, Mr. Glass. Thank y'all for coming, ma'am. After Mr. Glass, we have LaDalvin Wimes. Mr. Wimes, good morning. You're here for first appearance accused of habitual offender, driving while license suspended. That's a 3rd-degree felony charge that you're accused of.
No.
Mr. Wimes, there is probable cause, and according to the Florida Department of Corrections website, you're on probation out of Gadsden County. You are still on probation, correct?
No, none of that is true. I ain't even in here for that.
You're not on probation, Mr. Wimes?
You talking about somebody else. I'm in here for a domestic charge.
This is Mr. Wines, the second one on the case.
I apologize, Mr. Wimes. I'm sorry. I'm confused. I was looking at Mr. Wiggins on my sheet. I took Mr. Glass out of order, Mr. Wimes, and so I was looking at the person after Mr. Glass. That's my mistake. Let me go back up to the one above Mr. Glass, which is LaDalvin Wimes. Mr. Wimes, you're accused of 1 count of tampering with a victim and 1 count of domestic battery by strangulation. That's what you're accused of. Mr. Wimes, there is probable cause in those charges. Mr. Wimes, I think you're entitled to a bond as far as I can tell. Let me make sure that the attorneys don't have any additional information before I set that bond. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
So, Mr. Wimes, in your case, I have looked at your criminal history also, Mr. Wimes, and it shows a prior battery by strangulation that was dismissed. It was dismissed. And then there's another battery charge, Leon County, obstruction of justice. No, that's this one. Okay. So not a whole lot of criminal history, but there's enough there, and the complaint's enough that I'm not going to give you a conditional release, but I am going to set you a bond because I think you're entitled to one. These are 2 third-degree felony bonds, Mr. Wimes. I'm going to set you my normal bond I set for people that don't have much criminal history, and that's $5,000 on a 3rd-degree felony. You have 2 of those charges, so your total bond, Mr. Wimes, is $10,000 cash or surety. Cash or surety means you don't have to come up with all the money. You can go through a bondsman, Mr. Wimes. That's what a surety bond is. So in just a few minutes, you're going to get to use a phone, contact whoever you wish, friends or family or bondsman. You post the bond, you'll be released immediately. Mr. Wimes, if you're not able to post the bond, the public defender's office will be in contact with you at the jail. Mr. Wimes, you're also going to be getting a notice for your next court date, which would be February the 3rd at 8:30. Mr. Wimes, do you have any questions?
No, sir. So with the 10,000 bond, that means it's actually $1,000, right? $1,000 bond.
If they charge you 10%, some places will take less than 10%. Some places may take 500 up front and work with payments on the rest. But yes, 10% of the 10,000 would be 1,000, but that's negotiable with the bondsman.
Your Honor, somebody else has no contact with the victim.
Yeah, no contact the alleged victim, Mr. Wimes. Thank you, Mr. Mitchell. Now we get to Mr. Wiggins, Marquez Wiggins.
I'll actually credit Dawn on that one. She brought it to my attention.
She reminded you. Mr. Wiggins, good morning. Mr. Wiggins, you're accused of 1 count of habitual offender, driving while license suspended. Yours is the case where Department of Corrections website shows that you're on probation out of Gadsden County. Are you still on probation?
Yes, sir.
Mr. Wiggins, I think you're entitled to a bond in the new charge, but not necessarily on the VOP. I'm going to ask the attorneys to see what information they have. Then we're going to go from there. Mr. McDaniel, anything on behalf of Mr. Wiggins?
Nothing, Your Honor.
Mr. Mitchell.
We just request a 7-day hold. I'll be in contact with Gadsden County. I'll see if I can get in touch with possibly ASA Edwards. I can reach him a lot easier and see if we can get a warrant out for that BOP if they're going to go forward.
Thank you. So, Mr. Wiggins, I'm going to set you a bond in the new case. The bond in the new case is going to be $10,000 cash or surety. The reason the bond is that amount is because you're already on probation. That bond has a condition that you not drive a motor vehicle. The reason for that is you've got a habitual designation from 2024, I think. So you've got a 5-year suspension, so you can't be driving. But don't try to post the bond, Mr. Wiggins, because for 7 days, I'm going to hold you with no bond. I'm going to ask Mr. Mitchell to notify the authorities in Gadsden County and see if they're going to seek a warrant or not on the VOP. Have no idea if they will or not. If they don't have a warrant within 7 days, you'll come back to first appearance. I release that hold on you. you'll be free to post bond at that point. If they do have a warrant, we'll see if that warrant has a bond or not. So I'll see you in 7 days. Mr. Wiggins, any questions?
No, sir.
All right, sir, I'll see you in 7 days. Let's do give him a notice for his next court date, please. That would be February the 3rd at 8:30. And who do we have next? My list is kind of mixed up. I'm sorry?
Dana McDonald.
Is it Deny McDonald? Mr. McDonald, good morning. You're back for your first appeared this weekend by Judge Garcia, I believe, for criminal mischief. The complaint, I guess the complaint says over 100, but less than 1,000, but the complaint never gives any value at all to the damage that was allegedly done. So, Mr. Mitchell, I'm going to ask you to notify the officer and remind them that we have to assume it's the lowest degree crime, a second degree misdemeanor, if they don't put a value in there. So, Mr. McDonald, I'm appointing the public defender's officer to represent you. Please listen to Mr. McDaniel, your attorney.
Your Honor, we're just going to ask that Ms. McDonald get a conditional release and a court date for February 2nd, 9 o'clock.
The jail sheet says she was given a conditional release this weekend. Is that not accurate?
Well, her parents were going to post bond from Ohio, and they've had problems. I don't know. It's a $250 bond, but I think they're trying to go through a bail bondsman who probably is not going to write a bond on $250. And I don't know if they can't figure out how to send the cash.
Okay. So just a second, ma'am. Just a second, ma'am. I need some information from the jailer first. So Corporal, I need your help with this one.
Hey.
So Corporal, the first appearance sheet says conditional release or $1,000 bond. I have not watched the video. Was she offered a conditional release this weekend or not? And Mr. McDaniel says 250, but my jail sheet says 1,000. So I need to be clear on that.
According to the first appearance sheet, she had a conditional release or $1,000 bond for a week.
Yes, it was a conditional release or $1,000 bond. Someone told me, it may have been her that told me someone called me this morning. And I think it might have been the parents who ever called me. I was thinking they said 250.
So Ms. McDonald, you chose the bond, but then were unable to post it. Is that correct?
Yes, sir. My mom, I'm on scholarship. I play basketball for Chipola. My mom is in Ohio, so she told me to just take the bond so I wouldn't have to be going through probation and stuff like that, because I am a basketball player and in school. So when I tried to do that, the bondsmen were like, it was difficult for my mom because she's 19 hours away. So then my mom said it would just be best when I have this again to just choose a conditional release.
Okay.
Because I'm just
So you
trying
want
to
to
get back
accept?
to school.
Okay. You want to accept the conditional release that Judge Garcia offered you this weekend, correct?
Yes.
Okay. I'm gonna grant you the conditional release. Judge Garcia's already granted that, so there's no problem with that. What that means is you're going to get out of jail this morning. Now, let me tell you what's going to happen. They're going to let you get dressed in your regular clothes, and then they're going to the jail's going to bring you to the courthouse, because that's where the conditional release office is at. When you get to the courthouse, Mr. McDonald, you'll meet with Mr. Goodson or Mr. Ham, probably Mr. Goodson, the conditional release officer. You do conditional release? That's one. So Mr. Ham will meet with you, and then they'll go over the release with you. They'll give you a copy of all the rules in writing. They'll give you a chance to ask any questions, and then you'll be free to leave. You will have to be back in court on the court date of February 2nd at 9 a.m. They will give you that notice downstairs. They'll get you to sign for that notice. You do have a condition of no contact with the alleged victim, no contact at all with the person that's accused you of this. And you will be at the courthouse in probably 30 to 45 minutes. You can use the phone before you leave there to call friends or family to tell you for transportation purposes. You can be picked up in about 30 or 45 minutes at the courthouse after you meet with the officer. Ms. McDonald, do you have any questions?
No, sir. Thank you so much.
Yes, ma'am. Wish you the best. James Ammons.
James Ammons was returned to a cell, Your Honor, and next is Marley Owens.
Okay, Miss Owens, good morning, ma'am. I first appeared to you when I covered on Sunday, ma'am, for the charge of driving while license suspended or revoked knowingly. Miss Owens, I'm appointing the public defender's officer to represent you, ma'am. Please listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Ms. Owens, and she was going to accept the offer from the state, a 6-month probation for no valid driver's license, $400 fine. She can If she gets a valid driver's license within 60 days, that fine will be lowered to $300. She has signed a plea waiver form, waiving the right to jury trial and call witnesses.
Okay, I don't
write anything.
know anything about that offer because I told Mr. Mitchell that I would not necessarily opposed to probation if she had a job, a real job. And I'm not sure why it'd be 6 months anyway, because it appears she's got a prior.
Yeah. Sorry. That's on
So
me.
I don't think
the
she,
employment.
I don't think she has a prior.
I do have a
Let's
job,
start-
Your Honor.
Okay, Ms. Owens, the sheet from the first appearance pre-trial release sheet, the reason I didn't suggest probation to begin with is it says self-employed, and sometimes self-employed means you have a job. A lot of times it means you really don't have a job. So tell me about your employment, please.
Sir, I work for Hustle and Rubber. It's for my fiance. Underneath my fiance's, I get a paycheck. It's in Alabama, but I still get a paycheck. I mean, I get paid every week. It's called.
How many
Hustle and
hours a
Rubber.
week do you work?
It just really just depends. Usually over probably at least 60 hours a week.
Okay, so how long have you had that job?
For last year now, I know at least last year, yeah.
Okay, so have you got your tax return forms yet for 2025?
Not yet, sir, but I'm just waiting on them in the mail any day now.
Okay, so it's at least 30 hours a week every week, right?
Yes, sir.
Okay, and I believe on my driving record, I saw a prior because I talked to you about this weekend, prior driving license suspended. Is that not correct, Mr. McDaniel?
I think they're unknowingly. She has two of them, just, and they're both unknowingly, and they're both sitting there. That's the reason I was trying to do a no valid driver's license, because
This is an old one. This one's. Let me look her driving record up. I know there were two recent or more recent civil ones, but I think there's an older criminal one, but let's double check. So I have no problem with the probation based upon her employment. The question is, how much probation would it be?
Yes, sir.
This was the one I also asked you about amending from DWLSR to no valid DL. So that's why it would be 6 months probation at that point if we amended it to no valid DL.
Okay.
If she had a prior, I don't mind doing a year probation on a no valid driver's license. I don't have any objection to it, but I didn't.
You can only
see
do
one,
that.
so.
You can only do that if she has a prior no valid, though, if you're going to amend it. So let me go back and just because she does have a prior criminal driving license suspended in Holmes County in 2015.
Okay.
There are no prior civil ones showing up at all.
Okay.
Don't, you done messed up my stack. What do you need? You need something out of here?
Yeah, because I didn't just brought the bonds.
Okay, well, hang on just a second. Let me. Okay, so knowing that she has a prior, I don't know anything about the civil ones Mr. McDaniel's talking about. They may be pending or something, but they're not showing up on the driving record. Do you still want to change it to no valid driver's license?
Yeah, I have no objection to that.
And if you change it to no valid driver's license, does she have a prior no valid driver's license?
From that, I did not see a prior no valid DL.
Because
at least when I was looking through
that
it,
wouldn't necessarily show up on the driving record. Okay, so you need to understand, Ms. Owens, if I give you the 6 months on the no valid driver's license, I'm not going to let you terminate probation early because you have a prior
I understand that,
driving
sir.
license suspended or revoked. You're going to do the full 6 months. Knowing that, do you want to enter this plea?
Yes, sir.
All right, so I'm going to accept your plea of no contest to the charge of no valid driver's license, the amended charge. I'm going to withhold adjudication of guilt. I'm going to sentence you to 6 months probation.
Now, sir, will it help in any way?
Just a second. Let me get through and then I'll answer
Okay,
any
I'm
questions you
sorry.
have because I've got certain things I have to put on the record. Just a second. 6 months probation, no early termination, $400 court costs and fines, withhold adjudication. You'll be brought to the courthouse in just a little while, ma'am. You'll get to use the phone before you leave the jail. And then this case will be over other than you carrying out and completing the terms of your probation. Now, do you have questions, ma'am?
So when I get my driver's license fixed, it's not gonna, will it be helpful to that or?
It
or
will,
is that one
it
of my-
will. And let me tell you how. If you get a license within the first 60 days, instead of your fine being 400, it'll be lowered to 300. Yes, ma'am.
Okay, then that's all I needed to know. Thank
Any
you
other
so much.
questions?
No, sir.
Mr.
Thank
Goodson
you
has
so
a
much, Your
question.
Honor.
Thank you. Those are standard conditions I always put on there, and I forgot to do them this time. Mr. Goodson's reminded me. You do have a condition that you obtain a driver's license if one is reasonably available to you, and that you not drive a motor vehicle unless you have a valid license. Knowing those additional conditions are there, do you still want to enter this plea?
Yes, sir.
All right, man. Wish you the best.
Thank you so much.
Thank you. Mr. McDaniel, that's everything I had on my list as far as I can tell. Anything else from the public defender's office?
Okay, so we have two different victims here with
Same.
that carved out two different crimes, three crimes, two in one victim's case and a third one. So you've got three different crimes alleged, two indictments though, and they're both second degree felonies. So your problem is compounded. And was this carved out of the same event?
Yes, Your Honor.
Same.
Yes, sir.
Okay.
It's all kind of-
All right. All right. We'll see you back in 4 weeks. Okay.
Thank you, Judge. Next one is a plea.
Michaela Isaac. I know I'm pronouncing this incorrectly, but Brent, where's Mr. Turk? John, you raised your hand. You're not, you're John West. Oh, there's Brent. When did you see John was impersonating you? Yeah.
That's kind enough. You probably do a better job.
He certainly seems shorter. How do you pronounce your first name?
Michaela.
McKay. Oh,
You
I've
did
heard of
right.
that. Yes, sir. 25 CR 1460 is called Michaela Joseph Isaac. You are here with Mr. Turk, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in a summary fashion?
Yes, Judge.
In summary, this indictment alleges three paragraphs, which is kind of unusual. All right. I see. You were charged with the third degree felony of stalking, which carries with it no less than 2, no more than 10 years confinement in prison and a fine up to $10,000. But the grand jury has indicted you in stalking in three different ways. Looks like by threatening to commit bodily injury on someone, threatening to damage their vehicle, and threatening to damage their home. So each of those types of threats are individually a violation of law. I understand. What are we going to do, Mr. Turk, on this?
She's going to accept the 5-year deferred obligation.
What's the relationship to the victim?
I believe new girlfriend of boyfriend.
No,
No.
I've been with the man for 13 years and there was ex, and their stepbrother and stepsister. It's weird.
It's common.
Sounds weird.
Very.
But you knew them.
Yeah.
All right. So where are we going on? Allegation 1, paragraph 1. You got 3 different paragraphs here. Just doing one.
Yes.
Yes. Okay. And again, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, Judge.
In summary, Ms. Joseph, this indictment alleges in paragraph 1 that on or about September 25th, 2025 in Jefferson County, Texas, you committed a third degree felony of stalking. Do you understand what you were charged with here?
Yes.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range that is dealt with in this particular case?
So,
An agreement has been reached between the parties that you would be pleading guilty. not found guilty, but placed on a form of probation called deferred or unadjudicated probation, where you are not adjudicated guilty so long as you follow the terms and conditions of probation, which will be normal and customary for this type of offense. They include things like don't have any contact with the person, follow the law, things, much of the same rules that all of us here in this whole room have to follow. So there's no excuse for you not to follow these, and there's no excuse to fail. This would be for a period of 5 years. There would, among other conditions of probation, there is restitution that is owed in the amount of $4,683.51 to the complainant in this case, who's the victim. Is all of that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty?
Yes.
Ma'am,
Guilty.
are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 is tendered into evidence.
Objection.
And without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true at state, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Is this your signature right here?
Yes.
That's it?
Yes.
You write like a lawyer. Okay.
Maybe I can find some time to go to the school.
Well, that thing just stretches right out there. It looks like some kind of art form. Cool. A lot of letters in there. All right. Anything else to add? If not, I'm going to make the findings that, yes, Joseph, you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this third-degree felony of stalking. But I'm going to follow this agreement and defer or postpone any finding of guilt so long as you follow the terms and conditions of this probation order. The probation officer will be going over all of this with you, and you will sign it if all is well. And you are going to be placed on this deferred or unadjudicated probation for 5 years. You must pay restitution to the victim in an amount of $4,683.51. There will be other terms and conditions of probation, which include don't have any contact with the victim nor anyone on your behalf. You don't know this person, or you're not keeping tabs with her.
We should saying that kid that.
I've already told her, Judge, just call the police if she's having issues with her, if she's in her home. Don't go around her. Don't have anybody else.
You don't want to foul things up here, because if you fail, your probation could then be revoked. You could then be found guilty of this third-degree felony. And when you're found guilty, it lasts for your whole life. And then you can be sentenced up to 10 years in prison. You don't want that. Let me ask you on this restitution, how are you going to pay that back? How much can you pay monthly? Because you probably can't write a check for $4,683.51, right?
I can probably get my mom to help me with like 70.
Well, your mother isn't responsible for this. This is one of those things adults have to handle responsibility.
Well,
You need somehow it needs to get paid back. How much can you pay back per month? Yeah, I know you can't write a check for it right now, but I want to know how much you can pay per month so that we can figure out.
Probably 80 a month.
Ma'am, 80. I will start off with that. No less than 80 a month, but see, in in 12 months, what's 80? $960. So that's in a year, that puts you still 4.5 years away from completing this. But then you're on probation for 5 years. We shorten probation, by the way, for good behavior and taking care of all your responsibilities, including restitution. Every day I dismiss early deferred probation orders.
I will have it. I probably have some.
That's going to be I think all these other provisions, you're going to be able to figure out and follow, or else, that's not good. Because these are all, like I keep telling people, most of these are the things I have to follow. The same rules we all have to follow there. So it's not unusual or uncomfortable, but restitution is going to be different, okay? Here's the restitution orders. I'm going back to the probation office. Please sign those. You begin and do well. Thank you. Good luck. Steve Savoy.
Judge, I just recently got some discovery with it. I'd like some time to go over it with him. Possible.
When did that happen? When did you?
I want to say within the last week or so.
Well, that was recent.
I know, Judge, I'm slacking.
25 CR 1527 is called Steve Dillon Savoy. You're not the Grove Savoys, are you? No, sir. I grew up with the Grove Savoys. All right. You're charged with a state jail felony of child abuse or neglect. This carries with it, if convicted, up to 2 years in the state jail. It's very serious. What are you asking for, Mr. Pearl?
Can I get 45 days?
You got it. That's about 6 weeks.
Yeah, roughly, yeah. We're gonna give you a reset down the stations. What's that? That should be good. I think that. Oh, no, something. That's the problem.
Hold on. We're not through it on this one. Come on in, everybody.
They're gonna get you a reset. Say.
All right, this is.
Oh, we're not done yet, sorry.
Yeah, we're not done. What's the situation on the issue of the child? What's the relationship?
Your Honor, I don't believe there's any relationship. The facts of this are a bit unique.
Williams supposed to be supervising a 4-year-old, but it's not your child?
No.
Why were you taking care of this child?
I was not, sir.
Did the grand jury make this stuff up? I mean, they have some reason for it. Do you know what we're talking about here? Do you know the subject matter?
Yes, sir.
Your Honor, it was a false report. It wasn't an injury to a child.
The defendant claimed a child was unsupervised. Dead animals were accessible to this child. The front door of the residence was left unlocked, and the child was going hungry due to a lack of food in the home. So the defendant, it's alleged the defendant called law enforcement or authorities and made these allegations. That's what the grand jury alleges.
That's correct, Your Honor.
Which were deemed to be allegedly false.
Yes.
Okay, and if this occurred, then what happens is if this actually occurred, then the crime is filing a report that caused authorities to take action when there was not a valid basis for it. Because we're all busy doing other things that we're supposed to do, and we don't have any reason to be running off to wild hair chasing. So. It says the defendant submitted a report to Child Protective Services. And he was hired to remodel their home. And there was a disagreement. Asked not to return to remodel the home. And then later on, claims he observed neglect of the children. That's what all of this says. Have you heard about this? Yes. All right. Your glasses, 6 weeks.
Okay, just quiet.
Okay. We're resetting. Therese Simeon.
You don't need that.
Thank you, Jeff.
Judge, I have the media on this, but I don't have the witness message for some reason.
Sorry to hear that.
Yeah, me too.
25 CR 1528 is called Therese Shante Simeon. Is that you?
Yes.
And you were charged here with this indictment that was filed not long ago with the second-degree felony of burglary of a habitation, which carries with it no less than 2, no more than 20 years confinement in prison and a fine up to $10,000. So it's serious. What do you want to do today?
Judge, I need to get it reset and get.
You need to get it reset. How long?
4 weeks, fine.
Okay, I can only give it 4 weeks.
Let's go. Let me just, happy.
It's 4 weeks ago?
Yes, sir.
Okay. Get it reset in a sec.
Send me, yeah, I'm into that.
Alberto Toledo the third. 25 CR 1. That's awesome. 803 is called Alberto Toledo third. No answer in the courtroom. I asked the bailiff to call into the hallway for into the mall. Sometimes I think we're at the mall. Alberto Toledo the third.
Yeah.
You recognize anybody at all?
No response, Judge.
There's no response to that name being called in the courtroom. No response to the name being called in the hallway by the bailiffs. Defendant has failed to appear. His bond is $10,000. It is revoked for failure to appear. The bond is now doubled to $20,000, plus the defendant shall be required to have a GPS device at all times, so we know where he is when he's not in court, when he's supposed to be here, and a warrant shall be issued for his arrest. Okay. Dazani Matherson.
How are you?
That's John West. John, there you go.
Yes, sir. Yeah, that's fine.
25 CR 1665. You're Dazani Matherson?
Yes.
Here, is that yes?
Yes.
It's because so she can hear you. You were here with your attorney, Mr. West, and the state's attorney. You were charged here with the third-degree felony of stalking. We have another stalking case. What's going on out there? A lot of stalking. If convicted, this carries with it no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Are you familiar with the circumstances we're talking about, ma'am? Well, whatever happened there, it resulted in the grand jury indicting you. So that's why this is serious. Are you employed somewhere? Are you employed somewhere? You have a soft voice.
Yes, sir.
Where?
Okay.
That trailed off.
Yeah, you gotta talk really loud.
Yeah, I know you talk louder at Taco Bell. Come on, so people can hear you. All right. Once again, this carries with it up to 10 years in prison, and it'll ruin your job opportunities if you're found guilty. So you need to work through this responsibly. What do you want to do today?
Your Honor, initial appearance, if we can set up an announcement docket so I can get the discovery, go over it with my client, and then see if we can resolve this.
All right. Is there anything? Well, let me ask you, you're familiar with what the allegations are here?
Yes, sir.
Okay. You can't have any contact with this person that's alleged to be the victim. Do you understand? You understand? You have to speak out to me. Okay. Nor can anyone on your behalf go and contact her. Do you understand? That can be more trouble. You don't work with this person, do you?
No, sir.
Okay, well, if you work, I mean, you'd have a problem working with them. All right, get a reset.
All right, I think it's time to switch things up. Let's go back up to Michigan. Spend a little time with Judge Mom.
Happened alongside defendant Caleb Dobson, present this morning for a scheduled sentencing and bond violation matter.
All right, thank you. And sir, your name for the record, please.
Caleb Dobson.
Okay, and thank you for dressing appropriately for court. All right, so originally, this matter was scheduled for sentencing November 12th, and this is on your client's plea to an amended charge of operating while intoxicated first offense. It had been reduced, the two original charges of operating while intoxicated second offense had been dismissed. We originally scheduled this for sentencing November 12th. It was not scheduled, or we did not conduct it because your client was interested in sobriety court in the 17th District Court. It appears as though there was outreach attempted by the 17th District Court sobriety court to no avail to your client. And so then we were set for January 7th. We did not call the case on the record. You were set to be in another court, and we were running behind in our docket. It was extremely large that day. And then you indicated you're still working with treatment court for your client. Which treatment court was that?
So, Your Honor, I had initially followed up with the 17th District Court. I was in contact with the clerk from that court. She did advise me, though, regrettably in January, following our last appearance for you, that they were no longer accepting transfers, and so we weren't able to proceed with 17th District Court. However, after speaking with Ms. Shaw from the probation department, we did also begin to make contact with Harper Woods. However, they did not indicate a response. In terms of acceptance at this point, we would need to go through a more formal screening process with them as well. So we did make some efforts. And if Your Honor, if I may expand on the efforts, both in terms of what Mr. Dobson received from 17th District, as well as there were follow-up efforts on his part that are not necessarily noted or reported in the PSI, but I can speak on that as well.
Okay, well, a couple things. So, so here, counsel, is my question. So you have Harper Woods that you've reached out to on behalf of your client. When did you reach out to Harper Woods?
Just prior to the holiday, I received the response from 17th District Court that they were not accepting transfers on January 12th. From there, I did follow up with both Ms. Shaw as well as make a telephone call to the sobriety court, treatment court in Harper Woods. And I was awaiting response to information. And then unfortunately with the MLK Day closure this past Monday, that kind of further delayed a more formal response. So that was something that we were looking into. However, with respect to that, we are also to the extent or degree that we are able to, as it relates to the Dearborn Heights matter, we have been in contact with that court as well. And we are prepared to make arrangements through them with respect to help securing a transfer into a.
So tell me about the outreach from the 17th District Court that indicates that your client did not respond. And I will note, here's that sentencing was adjourned on as defendant was interested in sobriety court. This was from the November 12th date. Then it says defendant did not respond to calls / emails from 17th District Court sobriety court. Note, defendant expressed interest in this same sobriety court in July with no further contact at that time as well. So did you seek, well, right, because you were arraigned July 7th. So part of the problem that I'm having, counsel, is that it appears as though the attempt for sobriety court by your client has been ongoing for 6 months. 6 months. I run a treatment court in this court, mental health treatment court. I know that it does not take 6 months.
Of course.
For somebody to complete screening, have eligibility determined or otherwise. So why is it taking 6 months?
Yes, Your Honor. Certainly I can speak on that. And I would just note for the record as well. So I, as retained counsel, was substituted in on or about December 15th. So in a large sense, I've been playing a little bit of catch up with respect to the history of this matter. I note that only to say, from what I've learned from both speaking with Mr. Dobson from the other courts and seeing some of the communications, namely that being some emails that Mr. Dobson had received after the original sentencing date, he had received a new email from Redford at the very end of November, where they, again, that was an email where they go through the various phases and such. Mr. Dobson did show me a call log where he did attempt to call them several times in December to be responsive as part of that process, which I understand is much later than July.
I understand, but let me just ask a follow-up to that. Why didn't you just respond via email, sir?
Why didn't? She was asking why you didn't respond via to their email. Your Honor, if I may just very briefly interject before I allow Mr. Dobson to further respond to the question. One of the things that I've learned, and particularly at the end of December and early January, and I actually learned a great deal of this from Mr. Dobson's mother, who was able to be present on January 7th, because she does now live out of state. I've learned that Mr. Dobson has several very significant intellectual and learning challenges or disabilities. And I believe from speaking with Mr. Dobson and his family that those challenges or disabilities very significantly impacted his understanding, both in terms of document intake completion, understanding what his obligations or responsibilities were. Mr. Dobson has explained to me that over several instances or courses, primarily closer to July, when he did first express interest in this, he was under the impression that it was the appointed counsel at that time that was in coordination with the court. I understand that he should know that it is his responsibility, that he does need to be responsive and engaged. I would say that he's certainly, in that frame at this particular time. Unfortunately, though, from about July up until October, he operated on a faulty understanding, a faulty belief that it was the appointed counsel or his attorney was the individual to be in coordination for screening purposes. I've explained to him how that is a misunderstanding. I have explained to him how he does have to be, responsive, that, he has to go through the screening, that can't be done for him, things of that nature. So since I've engaged with Mr. Dobson and have worked extremely closely with him, I do believe that there has been a very significant, change and development in his own understanding of what these circumstances are, what sobriety court, means, entails, what his obligations and responsibilities are. And this is with absolutely, no disrespect to his former counsel. I think there was a night and day difference in terms of what he understood then versus what he understands now. And I've tried to work very closely with him, understanding those challenges or disabilities that are impacting his understanding, his reading, his completion of these documents. So I'm right there with you, Your Honor. I know that, sobriety court is a process that it does, entail to go through the screening, but it should not take 6 months. I only wish that I could have engaged with Mr. Dobson that much earlier to be, that much more involved with him to have ensured that this could be done, timely and successfully. But
So what are the, you indicated there are some intellectual disabilities for your client. What are those?
So Your Honor, Mr. Dobson has been formally diagnosed with ADHD, obsessive compulsive disorder, with I think a more extreme or significant qualifier that they've attached to it. Now, I've worked really closely with his mom to try to understand the more technical or formal terminology, but he has been diagnosed as he and his family have described it as slow learner. He's been on lifelong IEPs throughout his entire schooling. I was trying to get copies of that, but unfortunately, I wasn't able to receive that. His family hasn't preserved from his high school and lower education, but they have noted to me, Mr. Dobson's been very forthcoming with me that as difficult as it is to talk about these challenges, because he's very proud of himself for being able to be successful in school and overcome them, but they are very significant. And so I wish I had a more formal term than slow learner, as his family has called it, but they have acknowledged to me that he was on IEPs from an extremely young age up and through the completion of high school.
And was that from the ADHD diagnosis or from a learning disability?
I think it's from learning disability, Your Honor. I think the ADHD is secondary, but that I did want to acknowledge that one because I do have the more formal terminology for that.
Okay, and sir, how are you doing in your classes regarding electrical engineering?
I graduated, Your Honor.
Okay, and so when did you graduate?
I believe terrible with months. I believe it was October.
October of 2025, Your Honor.
Okay, and so when you graduated, did you graduate with a diploma, a certificate,
a diploma?
Okay, and so what was your grade point average when you graduated?
It was a 3.5.
That's great for electrical engineering, because that makes my head hurt. Right.
Your Honor,
So-
he's doing extremely well.
Yes, and that's
Good
great.
Job opportunity that unfortunately they had to rescind just due to the pending matters, but they did, the individual we spoke with did indicate that, at the right time in the future, if he's still interested, they will be happy to take him.
Okay, and that's good, sir. I ask those questions, counsel, because I also have children that have, one has ADHD, another one has learning disability. That's never once been utilized as an acceptable excuse to not follow directions or to not understand something. And I would beg to disagree that your client didn't understand some of what his responsibilities were. Perhaps he may not understand the criminal procedure, although I also find that hard to believe since this is not his first time, especially with this offense. And so I can understand your client has had some learning challenges and whatnot, has had IEPs, but I do not find that that's an excuse or an acceptable excuse to have prolonged the treatment court for 6 months.
Absolutely. And Your Honor, I only interject just to be very clear in this particular point. I'm not trying to provide this as an excuse or to otherwise explain Mr. Dobson's failures in that regard, but rather I simply provide it for context. Because, quite frankly, Your Honor, what I do think is significant and noteworthy is there are additional efforts I have not necessarily been able to provide on the record quite yet, but there are other efforts that Mr. Dobson has meaningfully self-initiated following December 15th and the substitution of counsel that I do think speak to the change of understanding, the change of both appreciation and engagement. To that point, Your Honor, Mr. Dobson has commenced both a course of AA participation. He has been attending AA on a regular basis since December 23rd, Your Honor. He also had engaged and reached out to counseling. Unfortunately, he wasn't able to complete a counseling session because after enrolling and engaging, they rescinded because they wouldn't accept his insurance, and he doesn't have sufficient out-of-pocket funds to only go through insurance. So we were either through the court, through sobriety court, or otherwise seeking to find support in that sense. But he has engaged in several efforts that are self-initiated with the assistance of counsel. And so I have, fortunately seen significant turnaround in short time. I understand that's a much shorter window of time compared to the period prior, but I do think that the efforts he is engaging in at this time are reflective of a renewed, deeper understanding and appreciation.
Okay, and I can appreciate that, counsel. So my question is this: has your client contacted his insurance company for a list of treatment providers that accept his insurance?
That's what I was currently about to do.
About to do. When did you begin your quest for treatment? And last week?
Last week was the last update from them. I have worked with him much earlier on. I think part of the delay with going through his insurance to find other providers was in large part because when he first connected with this particular provider and they had indicated that they take his insurance, and he had ceased looking elsewhere because he was operating on the response indicating that they were working with him or scheduling with him, only to then be told that they weren't taking his insurance and that he needed to look elsewhere. His father has excellent insurance through Ford, right?
Yeah.
Through Ford Motor Company. And so they were beginning to explore what options are available through that as well.
I also like to add, Your Honor, as silly as it may sound, I did not think to call my insurance. My mother-in-law told me, hey, you should call your insurance. So that's why it took now. Someone had to bring it for me, and that's why I'm going to do it.
You're married?
No, I'm not married. It's just easier to call her that.
His girlfriend's mother's. He and his girlfriend do reside together now. It is truly like a partnership. Mr. Dobson is quite young, but what I found from speaking both with him and his partner is they are the quintessential older couple in a younger body. So they are not married, but very much my impression is they live very much like a married couple.
Okay. So let me do this. Well, at what stage counsel is, so let me, hear how I ask my questions because I'm not sure if we're going to, what's your plan for the bond violation?
So, Your Honor, I did want to advise the court that I was contacted, but just prior to MLK Day from the officer in charge out of Dearborn Heights, that charge was just filed. I have filed my appearance with them. They did set an arraignment date, albeit the court set that arraignment date for February 27th. However, I've been in contact with the court. They've advised us that we are able to appear on any Friday for purposes of having Mr. Dobson arraigned in the 20th District Court. My request to the court for sentencing or for bond violation was if the court were to place Mr. Dobson on a period of probation so that the court maintains strict oversight and conditions over Mr. Dobson, we are in a position where we can have him arraigned perhaps this Friday, as we were beginning to talk about. So I did want to advise the court that as it relates to that matter, we have engaged with that court. We are responsive to that court. We are planning to have Mr. Dobson arraigned. So I don't know if the court is either inclined to place Mr. Dobson on a period of probation or would otherwise prefer to provide one more brief adjournment for purposes of addressing that, following up on the Harperwood Sobriety Court or counseling for purposes of ensuring Mr. Dobson has adequate rehabilitative resources.
So I'm not opposed, counsel, to setting out the sentencing one more time to perhaps for you to reach a global resolution as far as both cases being referred to sobriety court. Here's a couple challenges though. One, your client lives in Redford. I don't know how easy it will be for him to get to Harper Woods. So that's something that needs to be looked at. There's also a sobriety court in Dearborn in the 19th District Court. I don't know if they have any openings or not. So I suggest those, since those are a bit more geographically convenient for your client. I was intending on conducting the bond violation today. I don't know if you've spoken to your client regarding the bond violation and whether or not he's wanting to set this for a hearing or if he's pleading guilty, what that looks like. I don't know what you've indicated.
Your Honor, I have had an opportunity to speak with Mr. Dobson. The nature of the violation, as he and I have discussed, I do not believe is necessarily appropriate for a hearing. Mr. Dobson is prepared to respond to the violation allegation. And very much, as the court indicated in the inclination, we are hopeful that the court would provide that opportunity for a global resolution.
Okay, so I'm going to arraign you on the bond violation. And obviously the bond violation is that you violated bond by, it's alleged consuming alcohol in Dearborn Heights and then arrested for operating while intoxicated, third offense. And further, that you were at the same time also arrested for driving while license suspended. So those are the charges that are, sorry, Alan, that are alleged for the bond violation. So I'm going to indicate a plea of not guilty. And counsel, it would behoove you and your client both if you can take your client, get your client into the 20th District Court sooner than later, because I'm only going to go out 4 weeks. That gives you time to handle the arraignment, the probable cause conference, speak to whoever you have to speak with at the Wayne County Prosecutor's Office, and communicate with the treatment courts that you're looking into.
Thank you, Your Honor. We appreciate the court's consideration.
Mr. Dobson, how'd you get here today?
Uber.
How much did that cost you?
I honestly didn't even look.
Well, pull out your phone. Pull up the app. Let's see what it says.
It was $30, Your Honor.
What are you typing in there, sir?
Oh, no, I was on Chase. I was looking at them charging me.
Oh, okay, I was having you pull up the Uber app.
Yeah. Yeah, use that.
Does February 25th work for you both?
Yes, Your Honor.
Does the afternoon work, counsel?
Yes, Your Honor.
Okay. 1:30 p.m.
Yes.
From the Uber app pulled up?
No, it's not pulling up.
And here's what the court's going to do as well. The court's going to amend, let me see. Amend your bond condition to include an alcohol tether. Actually, we're going to do a sober link, and you're going to test 6 times a day, sir.
Thank you, Your Honor.
I have some serious concerns for the safety of the public. So I find that that will be one tool whereby testing every 4 hours will give this court some confidence that you're not consuming alcohol. No kratom, nothing, no substance, sir, unless it's recommended by your treating physician.
Yes, Your Honor.
No kratom, no anything that you can buy in the store that has hallucinogenic changes, some opioid-like responses. Nothing. Stop over at probation. Somebody will be with you shortly to give you information regarding the sober link. Okay?
Thank you, Your Honor.
Thank you, Your Honor.
And just be aware, counsel, I am not inclined to adjourn because there's not been a response by the Wayne County Prosecutor's Office, or there's not been any outreach to the treatment courts. There's a multitude of different treatment courts you can reach out to. I've given you 5 weeks.
Quite frankly, I would not dare ask for another adjournment, even just looking at the record, understanding, the circumstances. We are very prepared to make sure that we are promptly able to resolve this.
All right, very good. Thank you. Have a good day.
Likewise.
A dog-related case that was taken under a delayed sentence to potentially have the case be dismissed. The only thing that I needed to confirm, I haven't heard that there were any other issues with the animal in question. I just had to confirm whether or not the $200 has been paid. Did you pay that, Ms. Godin?
Yes, I paid it. It was either last week or the week before.
All right, can you check that out?
I hope you ain't had nobody called in.
Well, we'll be able to verify that, okay? So we're just checking on it right now. The most recent update that I had still had a $200 balance, but that was last week or so. It is, my staff just verified it's a 0 balance. Okay. All right, so this should be a very simple, straightforward hearing. I will note that you have complied with all terms, and based on your compliance, the case is dismissed and the file is closed. So good luck going forward. Hope you have no further issues like this, and good luck to you.
Thank you so much. I appreciate it.
All right, Norman Jackson is here for a review. Let's take a look here. 2501221, Mr. Jackson, can you state your name?
Norman Leroy Jackson.
All right. Jackson, how are you doing?
I'm all right.
All right, so when I saw Mr. Jackson, I adjourned this out. Said that I would suspend jail and just give fines and costs on this, as long as he didn't pick up any new criminal charges. And we're set for a review today. Interesting. We set this, I asked to set it for a review in 6 months. We're back here in 4 months. But Mr. Jackson, I'm looking at your criminal record. It doesn't look like you picked up any new charges. Is that right?
Right?
You haven't been in any other trouble, right?
No.
Good job, Mr. Jackson. All that's left is that you owe $250. Are you working now?
No.
All right, where are you staying?
I'm staying with my mother. I'm disabled.
Okay, all right. Is mom there with you?
No.
His other guardian, I'm his sister, I'm here.
Oh, great. Okay. So, so for 4 months, originally I wanted this to be set out 6 months. For some reason, my staff put it up at 4 months. But because he showed up today and because he hasn't picked up any new criminal charges, the only part of this that's left is the $250. But I'm going to make one more offer to Mr. Jackson. If he can continue to stay out of trouble for another 2 months, since again, my original plan was 6 months, all right? We're just here a little early. If he can stay out of trouble for another 2 months, then I'll waive his fines and costs. And he doesn't have to worry about trying to figure out how to get $250 when he's disabled. Do you understand that, Mr. Jackson?
Yeah.
Can you keep
Yes.
staying out of trouble?
Yes.
All right, so ma'am, you're his guardian, you're, are you hearing what the court's saying here? As long as he stays out of trouble, that $250 that is still outstanding, I'll waive that for him?
Yes, sir.
Okay. So I appreciate you looking out for Mr. Jackson. I'm glad Mr. Jackson is staying out of trouble. Stay away from alcohol. Doesn't do anything for you but get you in trouble, right?
Right.
So I will adjourn this for 60 days. If no new criminal contact, and waive the $250 and close the file. All right, I think we got a plan there. All right, that way I can save him some money and he can continue to stay out of trouble. All right, we'll keep it simple. Thank you, ma'am. Good luck, Mr. Jackson.
All right. Thank you.
We'll send a notice in the mail. We're gonna still send it to the 13-mile address, right?
Yeah.
All right.
Yeah.
Good luck, sir.
Okay, friends. Again, court's starting to come online now. Let's stay in Michigan, but let's say good morning to Brian Oakley.
What's that? You were able to steer my client scene right in line as cooperating with the probation department.
Good. Is he the guy that was just blotto the first time you brought him in here? Yeah, he's been doing really well. Oh, this is the guy that we couldn't get a hold of. Yeah.
Both of them are.
Good.
Morning, Your Honor, for the record, on behalf of the defendant, Your Honor, there is a plea agreement in the file that my client was responsible for the double.
Yep.
$500 fine.
All right, we'll do the double parking on the civil infraction. All right, Miss Gamble, is that your understanding of the agreement? You've agreed to pay $500. All right, I will accept that plea. I'll dismiss both the original charges. Can you pay the $500 today? Yeah, but understand that we don't do all this disposition until we get our money. So if we don't get the money within that due date, you're back dealing with all this. All right. So I can do you 30 days. Can you remember that? All right. So I'm not going to send you downstairs to do any paper with that downstairs. Just you get that paid within 30 days.
Thank you, Your Honor.
All right. Good luck. Always.
For Sumter, is this the new guy?
Where's it?
Both are here. Oh, that's right. People versus Miracle. Right. Morning, Council.
Morning, Your Honor, Joseph Hall, appearing before and on behalf here. Is now standing to my left, Spirit will say your name on the record. And Your Honor, I believe we do have a resolution contained in the file executed by my client, whereby he is going to plead guilty to one count of driving while license suspended. In exchange for that, the companion case is going to be dismissed. And as to the DWLS, the ticket along with that DWLS
speeding
is already defaulted in and I believe it's written up accordingly.
So you're asking me to set aside the default and dismiss?
Yes.
All right. Mr. Miracle, did you discuss your rights and options with counsel today? You understand all those? You understand the possible penalty for the charge of while license suspended, revoked, or denied? And understanding all that, are you in fact pleading guilty to that charge today?
Yes.
On October 2025, did you drive a vehicle in here on Township?
Yes.
And at that time, was your license suspended, revoked, or denied? Counsel satisfied?
Satisfied, Your Honor.
So am I. I'll dismiss the two charges from August 6th. What's the status of the license now?
I'm both currently, Mr. Miracle is not fully in Wayne County, for an official that does impact his license. He understands that this will constitute a violation of probation, that he is on and is prepared to deal with that through my office.
Okay.
As well as he's committed, Your Honor, to when he is first eligible to coming back, and he knows I do these and helping him to get full license restoration. I look forward to that.
Okay.
That bottom hand scribble, does it say no payments posted? Okay.
Are you working, sir?
Self-employed.
What do you do? What do you do?
Right.
Okay. How long?
2012.
Okay. You working now? Are you working now?
Currently not working. We got work just with the weather.
Yeah. So you're employed. You're just waiting for it to be above zero. Right. Okay. All right.
Well,
Yeah. Tangent alert. So a number of years ago, I met a guy, mutual friend, had a party. So I met this guy. He was a retired carpenter. He's from Michigan, moved to Alaska, was a framer in Alaska, and then moved back, So I'm talking to him. I grew up construction, so I'm talking to him. And I'm like, how long is your building season in Anchorage? He said, what do you mean? I'm like, well, do you just build like from June, July, and August? Or he said, no, we build year round. I'm like, man, I could never get a handle on working with gloves, nail pouches and gloves. And he said, me neither. That's probably why these don't work anymore. Because he worked year round in Anchorage, Alaska. He said, yeah, I got a lot of problems with these. Yeah.
I bet.
Yeah. Yeah. All right. Anything else I should know before I sentence on this file?
Your Honor, like I said, he's a hardworking guy. He knows my office well. He's going to move forward in the right way. So we would ask you to take some consideration of that.
All right. So we've got some old files we owe money on. It looks like $860. Part of that was the case I just kicked out. That was $170. Are you in a position to get some kind of payment set up on a regular basis, weekly, bi-weekly, monthly? Can you get some payment schedule set up on a regular basis?
Yes.
Can you commit to that today? Okay, do that before you get out of my building. All right, so on today's file, fines and costs are $500. I'm ordering 4 days on the court work program. Work program is assessed as an alternative to jail. I would suggest you go down and find out the quickest you can schedule them, because you're either going to work for me during the cold weather or you for the cold weather. So let's get these banged out so when you get a job that actually pays you, you can get it done. Any questions?
And they often weekends.
Weekends are tough for us.
Okay.
We're trying to gear up with more weekends, but right now, do the weekdays.
Gotcha.
But while you're not working, yeah, because we're not going to kill you out there. You're not going to work as hard for us out in this weather than you would for you. So with the money you already owe on the old stuff and the 500 day, go down and set up your payment plan.
Will do, Your Honor.
All right, good luck with your license when you get there.
Thank you. Judge,
Always a pleasure.
off the record, our friend John, helping him with something else, he's doing well.
Good.
I brought a Christmas basket for my daughter.
Always. Yeah, he's a sweet guy.
Take care of you.
Say hello to your big boss.
Well,
Caitlin Langley. Miss Langley, are you going forward today without benefit of an attorney? You've met with the prosecutor. Says here that you're going to plead responsible to a double parking civil infraction. You've agreed to pay fines at cost of $150, and the prosecutor wants me to dismiss the misdemeanor. That's all crew? True? All crew? Crew, that's correct and true both. Okay. Can you pay the $150 today? By 3? Okay. Questions? Good to go. Enjoy your day. Devin Rodkey. Like Rodney, but an K instead of an N. Did I pronounce it right?
Yes, sir.
Good morning.
Morning.
You're going forward today without benefit of an attorney?
Yes, sir.
Double parking for you?
Yes, sir.
Fine the cost 300?
Yes, sir.
And that's the way you want to resolve this today?
Yes, sir.
All right, I'll dismiss both charges from December 19th. Can you pay the 3 today? No.
No.
I'll give you a due date.
Yeah.
Look at the calendar. Tell me how long you need to pay 300. The reason is because all this is on hold until we get your money. Then we put it through to match the deal.
Yes, sir.
You looking for a due date? You can walk over there if your eyes aren't any good. Yeah. So
February 6th work.
February 6th, what day is that? Yep, I like Friday due dates. All right, any questions? Good to go. Stay warm. Meredith Allen. Good morning, ma'am. Are you going forward today without benefit of an attorney?
Yes.
And you've met with the prosecutor? You've agreed to plead responsible to a third charge, double parking. You've agreed to pay fines at cost of $500? Wonderful. I will dismiss the original charges from November 23rd. Can you pay the 5 today? Go down. You're probably going to be the first in line, so you'll get a big smile from the cashier. Have a great day. You're welcome. Yep.
That's on B
Yep.
at 500.
Yep. Good morning, Mr. Young.
Where's your honor?
Studio.
Dean, is it Crumpton? Come on up, sir. Mr. Crumpton, are you going forward today without benefit of an attorney? Let's see what you did. You made a deal with the prosecutor? Oh, all right, you're requesting an adjournment. Okay. March,
I think you want to talk about that.
yeah, March 12, 8 a.m.
Yes, whatever I have on. Yep.
You can get started. All right, Mr. Crumpton, we've got 2 files. You've got bond money on both. You've got a civil infraction, which is a speeding ticket. That bond is $300. You've got a misdemeanor, drove while license suspended, revoked, or denied. That bond is $500. If we switch your bonds, that'll give us enough money to pay off the civil infraction. You're done with it. Is that all right with you? Okay. Actually, probably the way to do it is just, yeah, and then whatever's left, put it on.
Put a
Yeah.
big bond on the other
All
one.
right. So have a seat. We're going to get you a paper notice for that new date. Questions? You're good to go.
So Lily says in the chat, lots of double parkers here. So double parking is this court's equivalent of allowing another to operate a motor vehicle, which is something that Judge Middleton and some other courts use. It's basically a legal loophole to be able to take the charge and plea it down to something that's basically just a fine. So that's what's going on.
All right, you're going to plead responsible to double parking. Prosecutor wants me to dismiss both charges from January 2nd, and you've agreed to pay $300, right? Can you do it today? Are you working? Where do you work? Mako? Mako? What do they do? All right, where are they at? Okay, how long you been there? Full time? Good. All right, so you owe some money on some other stuff too. Violation of permit, equipment violation. Oh, that's what these are. Yeah. You got to fail to display valid license 2 times. You got one from 23, one from 24. Almost $1,000. So are you in a... Great, but you still owe the money. Yeah. So are you in a position to commit to some payments? Weekly, bi-weekly, monthly, what works? All right. How much can you do and when can you start? No. 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 You're working full time.
That's a lot. Like 3,000. I can start paying the fees
Can you do 50 a month? Starting soon?
by February.
Pick a date. 10th? Yeah, we'll always take extra money. But this way, at least we got you nibbling away at it. All right, so you need to go downstairs and get that on paper before you get out of here. So you go to the front counter and tell them you're setting up a payment plan. Yep. Yep. All right, so that 300 plus what you already owe us, that's one big payment plan. All right, good luck. Good luck.
Barbara, thank you for the 5. Ellie, thanks you. It's very nice of you.
William Burrell. Burrell or Burrell? Mr. Burrell, you're going forward without an attorney, yes? You've made an agreement with the prosecutor, correct? You're going to pay $300 on the double parking and the other 2 get dismissed, right? All right, that's 2 charges from 12/12/25. Can you pay the 3 today? When? Due date over there if you can see the calendar. If you can't, take a walk. 10? 30 days? Yeah, we can do that. Any questions? All right, you can remember that? You don't need a piece of paper from us? All right. Did you hear what I said? If the money doesn't get paid when it was supposed to, then these are back up and you got to deal with them. Gotcha. Yeah, you should be. It's a good deal. Have a good day. You're welcome.
Yes, this is drive, they were driving. It's not working.
Yes, Hardaway. Miss Hardaway, are you going forward today without benefit of an attorney? Okay, so you're pleading responsible to impeding traffic and the misdemeanor charge from 12/31 is dismissed. That's the deal? Okay, impeding traffic is $180. Can you take care of that today? Go downstairs and get your smile and get on your way. You're welcome. Enjoy your day. Morning, counsel. Is it Hamadi? Come on up. Sir, are you going forward today without an attorney?
Yes, sir.
All right, so you made a deal to plead responsible to double parking and receive 2 dismissals from January 1, correct? And you've agreed to pay fines and costs of $300. Can you pay that today? Go downstairs and get a smile. We'll get you on your way as soon as we can. You're welcome. Enjoy your day.
Court does call the case of the people of the state of Michigan versus Sandra Law. Alex Chamalowski, for people.
Stephanie Can on behalf of Ms. Law. I will let him know. Your Honor,
State your name, please.
Sandra Law.
All right, where do we go?
Ms. Law has elected to waive her right to a preliminary exam. Your Honor, my client is outside of counsel's advice, asking to speak to the court, and she's also asking to have her daughter be allowed to speak to the court. I've informed her that her daughter will likely not be able to speak to the court because that is inappropriate, but she wanted me to ask.
All right, well, you can do the way, I don't know what you want to address to the court.
Can I read something to you, please? Your Honor, do you want to address the waiver first? How do you want to proceed?
You want to do the order? What is that, Ms. Cannon? No. If you want to do the waiver, we can, that's fine. Ma'am, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
Understand that you'll not have that hearing, you'll proceed to circuit court for further, bless you. You'll proceed to circuit court for further proceedings.
Yes.
All right. People also waive their right?
Yes.
Preliminary examination having been waived, found over to circuit court on count 1 with 2 following.
Your Honor, we would waive formal reading of the information, stand mute, and we're asking for our next pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
February 2nd at 1:30 before judgment.
February 2nd, 2026, 1:30, judge will move.
Can I read something to you, Your Honor?
As long as it's not too long, go ahead.
It's not. I apologize to you and your court for my situation of my stinking thinking attitude to allow my relapse and my time of sorrow. I've been caught in addiction for 15 years. Before this relapse, I have been sober for over a year. As of now, I have been incarcerated for 78 days, waiting for a plea deal to be sent to treatment. So far, there has been no eval. I was set to leave for treatment on a tether to Oakdale twice and subsequently been let down both times. There was a delay in my relapse due to bond differences in between both cases. I was not present for my Medicare renewal, so it has canceled. I'm concerned about me not being eligible to pay or have insurance pay for my long-term treatment. I worked hard in my sobriety to have a productive life. I went from having nothing in my life but a pipe and a rock to having things that make my life of importance: a job, schooling, a home, surrounded by my family, pets. I accumulated all that back. I write this to your court today to ask that I be released today to go back to my productive lifestyle that I struggled for. I have an awesome support system, a sponsor. I will continue outpatient treatment, drug testing, and my sobriety. I want a chance to show to this court I can be a responsible, clean, and sober out of jail. Thank you for your time.
Yes, I'm gonna be real. I've listened to this now 3-4 times. My position has not changed, and it is not going to change regarding this case. I did approve. The last one I approved was January 14th, her release to treatment.
Understood, Your Honor.
And that is what I said I would do every time. I approved it. I don't know what has happened there. Somebody else can look at that. But I'm not changing my position, Ms. Law. You can keep saying the same thing over and over. I'm not gonna do anything different.
I understand that, but what has held me back is with the treatment situation. Okay, I was put on a 90-day home arrest tether with Miss Washington's case. And me going to Oakdale, they set me back, they put me on a tether, and I couldn't leave. So my case with her is up, and I did my time in jail with her. It'd be Monday. So that's what set me back from treatment, and I have an eviction on my home that you did. I have to be out April 1st. So it's like I'm facing an eviction that I can't
I've
get my
heard all
possessions
of
out.
this, Ms. Law.
I
I
understand
know this. It's not like I'm operating in the dark. I have heard everything that you are telling me now 2, 3, 4 times.
I understand that, and I don't understand why I don't deserve a chance to do outpatient treatment and get my life back on track over one relapse. I mean,
Did
I'm-
you hear me?
Yes.
I approved outpatient treatment for you.
You didn't improve outpatient, you improved inpatient.
You want to see the form? I
Okay.
signed it January 14th. I'm done. Bond continue. Bye.
Thank you, Your Honor.
Goodbye.
I don't understand.
That was one case. One case.
Great start, Your Honor.
No, and you were involved, Ken. Thank you. Court calls the case, People versus Avion Johnson.
Morning, Your Honor. Chief Assistant Prosecutor Victoria Burton here is appearing on behalf of the people.
You were not supposed to let all that happen to me. Never mind.
Your Honor, I'm so sorry.
Good morning.
Good morning, Your Honor. Edward Drugas on behalf of Avion Johnson.
And Mr. Johnson, can you unmute and state your name, please, sir?
Good afternoon. Well, good morning. Avion Johnson.
Good morning, sir. All right, what are we doing?
Your Honor, I'm asking for an adjournment. We are downloading videos and we need some more time.
More time.
So
What am I doing? The 5th, I gotta skip that one. 5th and 12th. How long are you intending on being in Oakland? How long are you gonna be in Oakland County Jail? Do you know?
To May.
he's till May.
Till May, all right. Probable cause conference will be adjourned to February 12th. 2026, 9 a.m. Bond continued.
Thank you.
Yeah. Court calls the case of the People versus James Kimbrough.
And Chief Assistant Prosecutor Victoria Burton here is appearing on behalf of the people.
Edward Drugas on behalf of James Kimbrough.
James Kimbrough. All right.
Your Honor, we're just needing a brief adjournment. This case is going to be nallied.
And I'll adjourn this to the 5th. February 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Marcus Claybrown.
Morning, Your Honor.
Morning, Your Honor. Sam Bernstein for Marcus Claybrown. Mr. Claybrown, can you please state your name for the court?
Marcus Claybrown. Thank you.
Your Honor, we're asking for an adjournment to obtain a review discovery.
All right. Is he being held on anything else other than this?
Just this, I believe, Your Honor.
Probable cause conference, February 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus David Gilbert.
Carolyn Foster Tucker on behalf of David Gilbert. He is on Zoom? No. Your Honor, is he on Zoom? No, he's not on Zoom. I have no explanation for his absence. For the record, I'd ask for an adjournment.
Then what were you looking at the door? Never mind. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you, Your Honor.
Court calls case People versus Joseph Fonville.
Your Honor, Raymond Cook.
Brandon Bird on behalf of Joseph Fonville. Mr. Fonville, can you please state your full name for the record?
Joseph Fonville.
Thank you, sir. All right, you're requesting an adjournment.
I'm correct, Your Honor.
All right, is this the only thing he's held on?
I believe, is this the only thing?
Yeah.
I believe so.
Yeah.
All right.
Probable cause conference then will be February 5th, 2026, 9 a.m. Bond continue.
Just permission to address bond, Your Honor.
Go ahead.
Respectfully, my client indicated to us that he does have Medicaid and he's looking to be released to community health. It's not the fact that
To community, yeah,
mental health.
Yeah.
He's looking for some sort of mental health treatment. It's not the fact that he can't afford bond. He could have been posted bond if he wanted to, but actually, and he has a place to stay. So it's not like he's using the jail as housing either. But he's been trying to make sure he stays out of trouble. But he really wants to address some mental issues, and he's just asking this court, can he please be released to mental health?
I'm not gonna have an issue with that necessarily. I mean, he's got $1,000, 10% bond, I think it is on this case. So, I mean, it's not like we're really holding him. If you prepare an order, I'm sure the jail will use their resources to try to see something that will see if there's something available for him.
Thank you, Jan.
All right, thank you. So at this point, his bond will continue.
Thank you, sir. Any honorable court, have a great day.
Are you done?
Done.
That should make you stay.
As long as you're buying lunch.
Court calls the case, People versus Marissa Dix.
Good morning, Your Honor. Robert Ellman on behalf of Ms. Dix, who should be present over Zoom.
Good morning, Your Honor.
Good morning. State your name, please.
Marissa Dix.
Okay. I have before me a plea form that indicates that the defendant would be pleading to a doesn't say kind of plea. I'm presuming since I read the police report, it's a no contest.
That's correct, Your Honor. My apologies.
No contest plea to count 3 of stalking, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. Defendant is also agreeing to complete full 5 years probation with no early discharge. Not object to any personal protection order extension by the victim, participate in mental health treatment, complete a substance abuse assessment, and follow all recommendations from that assessment. That is what the defendant is agreeing to do. The prosecutor and defendant agree that the prosecutor will recommend that a current PPO violation will be dismissed. That's the court's full understanding of it.
The defense understanding as well.
Dix, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record.
Marissa Dix.
All right, you can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge or pleading no contest to the charge of stalking. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine, and up to 5 years probation. You understand that, ma'am?
Yes, I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes.
All right. Do you still wish to plead no contest?
Yes.
Basis for no contest plea?
Potential civil liability, Your Honor.
All right. To the charge of stalking, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You had executed or caused to be executed in advice of rights form?
I'm sorry, what was
Your
that?
Honor.
You caused to be executed in advice of rights form, meaning you went through it with your attorney and your attorney signed with permission, or you signed off on an advice of rights form?
Yes, I did.
All right. Do you have any question regarding any of those rights?
No, I do not.
All right. With particular attention to paragraph 5, which are your trial rights, you understand that you're waiving or giving up all of those rights?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
Not currently. Not yet.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
All right. Court has been provided and has reviewed 2 police reports. Both Ann Arbor Police Department reports for their case numbers 25-51811 and also for 25-40451. Any objections to the court having reviewed those reports?
No, Your Honor.
Based upon the review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ms. Dix, I do have to inform you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
People are not, Your Honor.
No, Your Honor.
And have I complied with the court?
Defense is satisfied.
Court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
February 18th at 9 a.m. before Judge Barry.
said 18th.
Yes.
February 18th, 2026, 8:30 before Judge Barry. 9 a.m. before Judge Barry, excuse me.
Thank you.
Bond will continue. Thank you. Thank you, Ms. Dix.
Thank you, Your Honor. Have a good day.
May I address Bond shortly? She still has a GPS tether on now that the charge has been reduced. Is there any chance of removal of the tether prior to sentencing?
I am not going to remove it.
Fair enough, Your Honor. Thank you.
Okay.
Thank you.
I like that kind of bond motion. Thank you, Mr. Elman.
Let's change it up. Let's stay in Michigan, but we'll go to Pontiac, the 50th District Court. Judge Jeremy Darnell Bowie. There we go.
I'm sorry. All right, we're here for an exam. Will we proceed?
Yes, Your Honor.
All right, any preliminary matters?
Yes, Your Honor. I have already shown exhibits, people exhibit 7, 9 to defense counsel. Exhibit 7 is the lab report, which is the direct comparison. Exhibit 8 is the certified copy of conviction for Mr. Denard. And exhibit 9 is the certified copy of conviction for Mr. Harper. I don't believe there's any objections to their admission.
None of it, Mr. Denard.
None on behalf of Mr. Harper either, Your Honor.
People's exhibit 7, 8, and 9 are admitted for preliminary examination purposes via stipulation. Any other preliminary matters?
There are a few other videos. I actually didn't, I apologize, Your Honor. I didn't ask if defense counsel was stipulating to the admission of the other exhibits. If not, I can lay a foundation for them.
All right. Mrs. Neal, can you hear when they stand at the tables? I don't know if we can accommodate the podium unless we take a testimony. Can you hear?
Yes, if they keep the mic close.
Yeah, can you pull them black mics closer to you? Yeah, all right. Just keep your voice up. Miss Brandy, your mic is kind of.
Yes, yes, Your Honor.
It's towards you.
Okay.
A little closer, Mr. Detective Brandy.
Is this better?
Yeah, you don't have to lean over, just keep your voice up.
Oh.
All right.
Any other matters?
No, Your Honor, except, can I publish these exhibits to the court? May I approach?
May I approach?
Thank you.
All right, I know that there's individuals in the court, so the court will put a mutual order to see frustration. If you remain in this court and you hear testimony, you'll be barred from testifying in circuit court if this case goes to trial at circuit court. I don't know the individuals in the court, I don't know the case. I'm gonna start with people in front of me to stand up and state their name. So ma'am, right there, can you stand up to state your name? All right, ma'am, to the left, state your name. Pete McCain. All right.
Devonica Denard. Here's your name number. Page one.
All right, so your name's for the record, so I don't know if the attorneys want to talk and see if they may know anything about this case. I'll give you about 2 minutes, but if you remain, you cannot testify at circuit court, so. Just want to make sure everybody understands and know that. So. Thank you.
Do you want to have any information about the case?
Okay. All right, so we may proceed.
Your Honor, people call Detective Robert Peter.
You swear or affirm subject to the pain, when further testimony gives court with the truth, the whole truth, and nothing but truth. I do, Your Honor. All right, you may be seated. Whenever you need the PowerPoint, just let me know. Share it against you.
Detective, how are you employed?
Oakley County Sheriff's Office.
How long have you been employed with the Oakley?
Can you start with his name and?
Oh, I'm so sorry. Detective, will you please state until you're fully aware?
Robert Bader, Robert, Bader, Bader.
Detective, you indicated you are employed by the Oakley County Sheriff's Office, correct?
Yes,
How long have you been employed with the Oakley County Sheriff's Office?
over 6 years now.
I'm going to direct your attention to September 23rd, 2025. Were you working that day?
Yes,
And were you contacted by Detective Michaels?
yes, I was.
Why were you contacted by Detective Michaels?
She came asking for assistance in a malicious destruction of property report that she was currently investigating. She stated that she had some video evidence that a vehicle that was damaged, back window was shot out from an apparent shootout that occurred in the Newman Court Apartments.
Where are the Newman Court Apartments located?
They're in between Kettering Avenue and Newman Lane within the city of Pontiac.
And did you get an address for where this a general address for where this NDOP took place?
I believe the victim's address was 736 Kettering. The incident occurred on the roadway of Kettering there.
Are you familiar with the Newman Court apartment complex?
Yes.
How are you familiar with the Newman Court apartment complex?
I've had numerous calls when I worked the road there. We have also multiple investigations that have occurred in that same apartment complex throughout the years.
Are you familiar with how the apartment complex is set up?
Yes.
Your Honor, may I please address the wait. Detective, do you recognize this photograph?
I do.
What is this image of?
This is an aerial map of the Newman Court Apartments.
For the record, can you just please describe how the Newman Court apartments are arranged?
It's set up in essentially a rectangle. There's Kettering Avenue, which runs north and south. On the west side of the apartment complex, and then Newman Avenue, which also runs north and south on the east side. We call them, refer to them as cut throughs. They're not technically streets, they're more or less parking lots, but they run through each of the middle of the apartment buildings to connect Kettering and Newman. And then each apartment is set up kind of in a square with a courtyard in the middle. And then there's longer townhome style apartments on the border perimeter.
Okay, so it looks like, well, let me go back. Does this image fairly and accurately depict the Newport apartment as you know them to be?
Yes.
Your Honor, at this time, I will move to admit People's proposed exhibit 1 is People's exhibit 1.
Any objection? On behalf of Mr. Harper Jr.,
No, Your Honor.
on behalf of Mr. Ding? No, Judge. Amen.
Okay, so we see that, there's a dot there indicating 736, is that correct?
Yes.
And that's the general area where the MDOP took place, correct?
Yes, correct.
After you received this information from Detective Michaels, what did you do?
She had security camera footage from her incident that the victim in that incident had provided her. I reviewed that security camera footage, which showed the shooting that occurred.
And now showing you what is People's proposed exhibit 2. Detective, do you recognize this still shot?
I do.
What is this still shot from?
This is a still shot from the Nest security camera from 736 Kettering of the MDOP.
And you reviewed this Nest security camera?
Yes.
And where within the Newman Court Apartments does this show?
This is, look, the street that you're looking at would be Kettering Avenue. It's looking essentially west from 736 Kettering towards the roadway, and then slightly to the south. To the left of the screen would be south, and to the north of the screen, or the right of the screen would be north.
And you had an opportunity to review the entirety of this Nest security camera footage?
Yes.
And do you think that the screenshot fairly and accurately shows the beginning of the video of the Nest security camera that was provided to you by Detective Michaels?
It appears to be yes.
Your Honor, at this time, I would move to admit People's proposed exhibit 2 as People's exhibit 2.
Any objection on behalf of Mr. Harper Jr.?
No, Your Honor.
Any objection on behalf of Mr. Denard? No, Judge. Admitted.
Thank you, Your Honor. Commissioner Publish?
You may.
I'm sorry, no, is there audio?
I can hear it.
You can hear it? I said, Your Honor, you need to be able to hear it.
Maybe if you turn it up on the computer, but I
I did, I just want to make sure.
tried.
Just.
I'm sorry, our court is not technically advanced.
Lindsay, thank you for the $10. Very much appreciate that. Very kind of you. And I hope you feel better soon. I really do.
Detective, this video cut short, is that correct?
Yes.
Why does it cut short?
I believe that's just the amount of time the Nest security motion sensor was set up. It only records for a certain amount of time based on the user settings.
And we can see it from this video that that it appears to be a newer white Jeep, is that correct?
Yes, ma'am.
After you reviewed this Nest security video, what did you do?
I then went to cross-reference this incident to see if I could locate it within the security camera footage for the actual Newman Court Apartments.
You indicated earlier that you're familiar with the Newman Court Apartments, correct?
Yes.
Are you familiar with the video surveillance system set up within the Newman Court Apartments?
Yes.
How are you familiar with them?
We've worked closely with the management of Newman Court Apartments for several years now of investigating incidents within their apartment complex, specifically shootings. They have multiple exterior security cameras fixated throughout the apartment complex and staggered within the courtyards, at the rear of the townhomes, and on the roadways in parking lots as well.
Cameras the same.
No, there are some older cameras that still exist that were several years old now. They don't have any audio recording, and they're a bit different quality. The newer ones have just been installed within the last year or so, and those are of different quality. There's many more of them, and almost all of them, I believe, record with audio as well.
Timestamps different between the newer cameras and the older.
Yes, just due to management and maintenance, some of the older cameras have timestamps that are a bit ahead of the real time, which the newer cameras are in line with real time.
How are you generally able to access these cameras? Do you have to go on site?
We can. We've also been provided through the Newman Court Department remote access to their system due to the fact that we constantly get called to Newman for incidents that occur after hours, and they did not want to have a delay in us responding to investigate these incidents.
So you yourself are able to directly download or view the surveillance video?
Yes, they've granted that remote access to the sheriff's office.
Were you able to locate video of the shooting that corresponds with the shooting that's shown on this Nest security camera, which is People's Exhibit 2?
Yes.
And where's the camera that captured the shooting located within the Newman Court apartments?
It would be affixed to one of the townhomes on the east perimeter, and it faces west through one of those cut-throughs westbound. So it captures both Newman Lane and you can see Kettering.
Did you review that video?
Yes,
And was there a timestamp on there?
there was.
What was the timestamp?
It was approximately 2:09 a.m.
Was this a newer camera or an older camera?
This is a newer camera.
So it would align with real time, correct?
Yes.
What was the date of the video that showed the shooting?
September 18th, 2025.
I'm showing you was People's Proposed Exhibit 3. Detective, do you recognize this still image?
I do.
And how do you recognize it?
This is the still image from that camera on Newman Lane that I was just talking about, showing down that cut through from Newman Lane to Kettering.
And does this still shot fairly and accurately depict the first image captured in the CCTV video of the shooting that took place at around approximately 2:09 a.m. September 18th, 2025?
Yes, it appears so.
Your Honor, at this time, I will move to admit People's Proposed Exhibit 3 is People's Exhibit 3.
Any objection, Mr. Harper Jr.?
No, Your Honor.
On behalf of Mr. Bernard?
No, Judge.
Admitted.
Thank you, Your Honor. Commissioner Polish?
Unanimous.
And for the record, in which part of the screen should we be directing our attention?
Your Honor, do you mind if I stand first?
Go ahead.
You want me to?
Since you're in the middle.
The area to focus on would be right up here in this, the common landmark that is in view right here. These are the mailboxes for the apartment complex. So the area to pay attention where the shooting occurs is right in this area. And then as it plays out, you can follow along and I can explain, I guess. For those of you who will be listening on the podcast side, sorry, no, I'm talking over. But on the podcast side, when we have these moments of silence, they're reviewing video.
how many individuals were you able to see on screen?
2.
And were you able to see, muzzle flashes from both individuals?
Yes.
How many gunshots approximately do you believe that you heard?
More than 10.
And so you see which direction do the shooters shoot?
Again, the camera is facing westbound. So to the right would be north and to the left would be south. The suspects come from the south and then they are shooting northbound up Kettering.
Which direction do the two shooters run?
They first run essentially south east down that cut through and then towards the east behind the East Road townhouses.
Were you able to locate any other videos that correspond directly with the shooting?
Yes.
And where, for videos specifically that would show the shooting or right around the time of the shooting, how many videos did you find?
There's multiple showing the events just preceding and then immediately following after, basically throughout the entire complex based on where the suspects were at and went to after.
I'm now showing you what is People's Proposed Exhibit 4. Detective, what are we looking at?
This is a still image of one of the older cameras from the Newman Court Apartments. This camera where we're looking at, that last camera view we're looking at, when you're looking down the cut through, the apartment blocks on the left in between Kettering and Newman. This is actually affixed to the northwest corner of that building, and it was facing south for Kettering. So towards the upper left corner would be south, and towards the right of the screen would be north, and that rotary right there is Kettering Avenue. So that cut through would be just, it would be in the background or the behind where the video is being shown.
Okay. Now, we can see the timestamp on here indicates 2:11:57. Is that timestamp correct?
No, it's approximately 4 or so minutes ahead of real time.
Is this because it is an older camera?
Correct. This is one of the older first ones that were installed at Newport.
Now, again, this is a still shot from a video. Are you familiar with the video associated with this still shot?
Yes.
Did you have an opportunity to review it?
Yes.
Does this still shot fairly and accurately depict the CCTV video as you observed it, showing a shooting on, or excuse me, showing incidents related to a shooting on September 18th, 2025?
Yes, it appears so.
Your Honor, at this time, I would move to admit People's Proposed Exhibit 4 as People's Exhibit 4.
On behalf of Mr. Harper Jr.,
No objection, Your Honor.
on behalf of Mr. Bernard,
No objection for exam purposes.
admitted.
Thank you.
Thank you, Your Honor. Commissioner Public?
Good night.
So while they're doing that real quick, Lindsay, 10 gifted memberships on top of your super chat earlier. Thank you so much. Appreciate it. Tim, 5 gifted memberships. Thank you very much. And Grandma TCF throws down $10. Thank you so much. You guys are the best. I mean, you really are. It's an amazing community. You guys always line up behind, line up behind me each and every day. And it continues to amaze me that some old balding guy yelling into a microphone and showing court gets so much love, and I appreciate it. Thank you. And Barbara gifting 5 memberships. Thank you, Barbara. Appreciate it very much. Again, if you're listening on the podcast side, when we have these moments of silence during this hearing, they're reviewing video.
Detective, you indicated earlier that this camera angle would be almost directly south of that cut through, correct?
Yes.
And so what we can see in this video is we can see 2 individuals getting out of the car and walking what would be north, correct?
That would be correct.
Which part of the Suburban did these two individuals get out of?
One is observed exiting from the rear driver's side passenger seat, and the other is observed exiting from the right passenger side.
And is there anything that you can notice about the Suburban? I know the quality is not great, but is there anything that you notice about the Suburban?
There appears to be some running boards on the side of it, like footsteps, I guess you would call them. It appears to be white as well.
Now, I'd like to go back. Now that you found videos of the shooting either immediately before or immediately after, did you find any additional security footage in addition to these videos to determine the identities of the shooter?
Yes.
So I'd like to go to approximately 1:45 a.m. Were you able to locate any CCTV of this Suburban?
Yes.
What video did you locate?
There's a video of it entering into the Newman Court Apartments initially, and then parking up in the northeast corner of the apartment complex, which would be on Newman Lane.
And there was CCTV of this, correct?
Yes.
CCTV that you reviewed yourself?
Yes.
And was there anything noticeable about the Suburban in those videos?
Again, we were able to, it's in color, we could tell that we was able to observe that it was a white colored Suburban. It had these running step boards on the sides, and that it was also missing the hubcap for the front right.
Were you also able to locate any CCTV concerning the white Jeep that we saw in this video?
Yes.
And at what time does the Jeep pull into the Newman Court Apartments?
Approximately 15 minutes later at approximately 2 a.m. on the 18th.
On the 18th. And where in the Newman Court Apartments did the Jeep initially pull in?
The same area, that northeast corner of the Newman Court Apartments from.
Where the Suburban is?
Correct. They're in the same general area.
At some point, did the occupants of the Suburban interact with the occupants of the Jeep?
Yes.
When?
Approximately 5-6 minutes after the Jeep arrives, just before the shooting occurs.
And Detective, if you could kind of set the scene, so we understand it's pretty late at night, but it's in these Newman Court Apartments. What's going on in the parking lot at this time?
There's general, I guess you would just kind of call them like block parties, hang out. During the nicer months of the year, Newman Court Apartments is very frequently busy, especially at late hours, of people just hanging out, drinking with, their neighbors or just people with friends that show up. There be multiple vehicles that pull up and just kind of hang out.
Are the cameras that are recording this particular area, the newer cameras or older cameras?
There's a mix of both, but primarily it's newer cameras now.
So do you have a clear view of the individuals that are in this area?
Yes.
So you indicated that at some point, the occupants of the Suburban interact with the occupants of the Jeep. Can you describe what this interaction looks like?
There appears to be a loud verbal altercation that occurs with at least some of the occupants of the Suburban, and with one of the occupants, primarily the driver of this Jeep, as he's walking by.
Did you recognize anyone in the videos from this interaction based on those videos?
Me personally, no.
Now, what happens after this argument or interaction takes place?
After the altercation takes place, there's two people from the essentially altercation that get into the Jeep, into the Suburban, excuse me. One of them gets into that rear driver's side passenger door. and the other gets into the front passenger seat of the Suburban. It's being driven by an unknown person who's remained in the vehicle, and then that Suburban proceeds to leave the parking spot that it was in, driving south on Newman, and then turning west into that first cut through to go to Kettering Avenue.
Okay, so we know that after this interaction takes place, occupants of both the Jeep and the Suburban, they get in and they drive, and they both leave that immediate area, correct?
Correct. The Suburban leaves first, and then shortly after, the driver gets into the Jeep and takes the same path.
So we know that the shooting occurs at approximately 2:09 a.m. Did you locate any other CCTV that showed immediately what happens immediately after the shooting takes place?
Yes.
What video did you observe?
There's video of the two suspects after we had seen them in the shooting video immediately as they ran towards the east to the back east row of apartments. There's cameras fixed to the rear of those townhomes, which capture the backyards, essentially the fence line of the east perimeter of Newman Court, and it shows them running and walking in back and forth from there.
I am showing you what is People's Proposed Exhibit 5. How do you recognize this still shot?
I do.
How do you recognize it?
This is a still shot from that one of the video cameras I was explaining from the rear of the townhomes. Specifically, this one, if you see the name timestamp there, it says back of 752. That would be this is a fixed to the back of 752 Newman Lane. And then the timestamps up there for September 8th, 2025, approximately 2:10 a.m.
And did you have an opportunity to review the video associated with this still shot?
Yes.
Is the still shot fairly and accurately depict the CCTV video as you observed it for the shooting that took place on or about September 18th, 2025?
Yes.
Your Honor, I would move to admit People's Proposed Exhibit 5 as People's Exhibit 5.
On behalf of Mr. Harper Jr.,
No objection, Your Honor.
on behalf of Mr. Bernard,
No objection for exam purposes.
admitted.
Your Honor, permission to publish? Actually, if I could, before I do that, is this timestamp correct?
Yes.
So this 2:09 a.m. is correct?
It's 2:10.
Excuse me, 2:10, I'm
Yeah.
sorry.
Correct. Yes.
So Detective, can you kind of describe what the video showed in this case?
So I guess we can establish just a directional frame of reference. The camera is facing east. So to the right is south and to the left is north. It showed the same two suspects from the prior video running northbound through the backyards from that cut through where they would have ran through. And then they stopped essentially right up towards the left-hand side of the screen north. That's would be the north end or northeast corner of the Newman Court Apartments. It appears they stopped and they appear to reload and exchange some ammunition or magazines for two black handguns, one that each had.
Now, did you find other CCTV similar to what we are observing in People's Exhibit 5?
Yes, there's again multiple CCTV cameras with audio, just like this one, that are affixed to the rear of the townhomes that stretch from here south to the end of the complex.
Would this video align with the video that we saw of the actual shooting itself and the direction in which the two individuals ran after the shooting took place?
Yes.
And is there other videos? Did you review other videos showing the defendants running throughout the apartment complex?
Yes.
How many videos?
At least a dozen or so. They remain back for almost about 30 minutes to 40 minutes in the back area, going back to and from north and southbound from the north end of the complex down to the south, and then back up several times as if they're trying to check out the area to make sure the coast was clear.
Objection, speculation, Judge.
That's fine, Your Honor.
It's fine.
Are they together the entire time?
Yes, on video, yes.
Do they ever separate?
Not that you can see on video, no.
So from the time from the shooting to pretty much the end of when they leave the Newman Court apartments, are the individuals shown on CCTV ever alone?
No.
Did you find any other CCTV that better shows the face and bodies of the two shooters?
Yes.
I'm showing you what is People's Proposed Exhibit 6. Detective, do you recognize the still shot?
Yes, I do.
It appears to be very similar to the still shot from the actual shooting, is that correct?
It is actually the same camera.
It's the same camera?
Yes.
Okay, and we see that the timestamp is a little different, is that correct?
Yes.
Is that because it corresponds with a different video?
Yes.
Did you review that video?
Yes.
Do you believe that this still shot fairly and accurately depicts the video, the CCTV video that's associated with the still shot
Yes.
and the shooting that took place on September 18, 2025?
Yes.
Your Honor, at this time, I will move to the People's Proposed Exhibit 6 and People's Exhibit 6.
We have Mr. Harper Jr.
No objection.
We have Mr. Bernard. No objection for example, Mr. Judge. In minute. Thank you.
Thank you, Your Honor. Commissioner Publish?
You may.
Okay, so Detective, if you can describe to the court a little bit about what this video shows.
This shows the two suspects emerging from there's a cut through between the apartment complex or the apartment buildings just to the left. Their screen again, this is facing west, so to the left would be south and to the right would be north. They come from the south walk north up, this is Newman Lane. They then stop and one of them walks up and appears to knock on a door to one of the apartments. All the other waits, and then afterwards they're seen walking down the sidewalk south.
The timestamp on this is 2:48 AM. Is this timestamp correct?
Yes.
There was also some, let me go back. Did you guys see some TV of the shooters eventually leaving the Newman Court Apartments?
Yes.
And around, if you recall, around what time they left the Newman Court Apartments?
It's a few minutes after this video. Actually, I believe it's around 2:50 AM.
Did they leave together?
Yes.
I'm showing you what is People's Proposed Exhibit 7. Detective, do you recognize the still shot?
I do.
How do you recognize that?
This is a still shot from one of the newer cameras towards the front, essentially entrance of Newman Court Apartments. This is one of the first lots for Newman Court. This view would be watching or facing west. So again, to the left would be south and to the right would be north. To establish some of the roadways, what we're actually looking at is the roadway right here. This is a roadway called Manhattan. And then Manhattan runs into directly the Newman Court Apartments, which would be to the right here. And then this road right here that it jogs into to the left, traveling north, that's Kettering Avenue. So the leasing office is technically this driveway right here.
The timestamp on this is 2:51, is that correct?
Yes.
And is that timestamp correct?
Yes.
Did you review the CCTV associated with this still shot?
Yes.
Does it fairly and accurately depict the video as you reviewed it?
Yes.
For a shooting that took place on or about September 18, 2025?
Yes.
Your Honor, at this time, I would move to admit People's Proposed Exhibit 7 as People's Exhibit 7.
All right, so I already have 7 as the lab report.
Oh, you're right, Your Honor. So I will amend this to have to exhibit, I'll amend this to People's Exhibit 10.
10, okay. All right. On behalf of Mr. Harper Jr.,
No objection for exam, Your Honor.
on behalf of Mr. Denard,
No objection, Judge. Thank you.
people exhibit 10 is amended.
Thank you, Your Honor. Commissioner Public?
You know. Swear affirm subject to the claims opposed to party, testimony given is correct, the truth, the whole truth, and nothing but truth.
I do, Your Honor.
All right, you may be seated.
Thank you.
Let me get ready for it.
Detective, can you please spell your full name for the record?
Nathaniel Rogers, NATHANIEL ROGERS.
How are you employed?
I'm a detective with the Oakland County Sheriff's Office.
How long have you been employed with the Oakland County Sheriff's Office?
Approximately 10 and a half years.
Were you working on September 30th, 2025?
I was.
Did you participate in the search warrant of 263 West Fairmont,
Yes, I did.
City of Pontiac County, Local, Michigan?
That's correct.
What kind of dwelling is 263 West Fairmont?
It's a single story, single family home.
Who also participated in that search warrant of that?
Members of the Oakland County Sheriff's Office SWAT team, Detective Hedrick, Detective Bader.
And based on the information that you had, who lived in that home?
William Harper.
Who was in 263 West Fairmont when you entered into the home?
When I entered into the home, it had already been secured, so it was just members of the SWAT team. There were a couple of individuals upstairs, but I did not identify them.
Right, did you go into the basement?
I did.
And did you find any documents that indicated who resided in the basement?
Yes, I found documents for William Harper in a bin in the nightstand adjacent to the bed.
I'm sorry, can you repeat that?
I found a Secretary of State receipt. It was a document for Mr. Harper. It was in a bin in the nightstand adjacent to the bed.
Anything else that indicated that the basement was where Mr. Harper resided?
I don't recall if I found anything else with his name on it.
Did you find anything else in that bin?
I did.
What did you find?
Found a Taurus G3C 9mm handgun,
What color is that handgun?
black.
And, what did you do with that handgun after you found it?
Handgun was photographed, secured, was seized as part of the search warrant, swabbed for DNA, and conveyed to the Oakland County Sheriff's Office crime lab for testing.
Did you check to see if it was loaded?
I did.
And was it loaded?
It was.
Fully loaded?
The magazine had rounds in it and it had a loaded chamber, yes.
Are you familiar with Alante Denard?
I am.
How are you familiar with Alante Denard?
I had numerous prior contacts with them in the city of Pontiac.
Law enforcement?
Correct.
Okay. And where were some of these interactions that you had with Mr. Denard?
The most recent interaction I had with him prior to this investigation was in June of 2021.
Do you see Mr. Denard in the courtroom today?
I do.
Can you please point to him and describe an article of clothing or something unique to him?
He is seated at the defense table, closest to the judge, wearing an orange jail uniform with a white undershirt.
I love the record reflect that the witnesses identified Mr. Denard.
So noted.
And did you have an opportunity to review some of the CCTV associated with the shooting that took place on September 18, 2025?
I did.
How many videos or photographs did you observe?
I don't recall specifically how many, but there were numerous different angles, different videos, and different still images that were captured and shown to me.
Did you recognize anyone from the videos or photographs?
I did. I was able to recognize and identify Mr. Denard.
Did you also participate in the execution of a search warrant at 4 Apple Lane?
I did.
As far as you know, resides at 4 Apple Lane.
Mr. Denard.
And what, if any, documents did you find that showed proof of residency for Mr. Denard?
His wallet was located within the dwelling.
And what, if anything, did you find in the home at 4 Apple Lane?
There was an empty gun case that was located in the bedroom.
Any clothing?
I don't recall specifically.
Would you have any reason to believe that there, or doubt me that there were a pair of boots that were covered?
No.
I have no further questions.
Cross on behalf of Mr. Harper Jr.
Ashley, thank you for gifting 5 memberships. Always appreciate your support. You mean a lot to me and to the channel, so thanks so much.
Fairmont, correct?
Correct.
And you didn't personally witness any shooting on September 18th, correct?
Correct.
And when you arrived at Fairmont, that was with the SWAT team?
Correct.
And were you one of the first individuals to enter the basement?
No, the SWAT team had the home secured and cleared prior to my entry.
So you did not observe Mr. Harper in the basement?
That's correct.
And then with respect to the discovery of the porous handgun, you located this in a bin under a nightstand?
I believe the bin was in the nightstand. Like there was an area for the bin to be placed in the nightstand.
How big was this bin? Can you describe it to us?
It was an open top bin. I'd have to refer to the photos taken at the search warrant to describe exactly how big it was.
Is this like a plastic type bin?
It was a storage type bin. It wasn't like a trash can. It was smaller in size, I would say.
Okay, and so it wasn't transparent,
I don't recall the color of it.
but you had to open it to look inside of it?
I don't believe it had a top on it.
Okay,
I had to manipulate it to search through it to discover the handgun, if that's what you're asking.
but the bin didn't have like Mr. Harper's name on it?
Not on the outside of it, no.
And then on the inside, you said you found a Secretary of State receipt?
That's correct.
And then you swapped the gun for DNA, is that correct?
I believe I did, yes.
And then you also separated the magazine in order to process that for prints, is that correct?
Yeah, I had it sent to the crime lab to see if they could lift any prints off of it.
You have not received any of those results back?
I do not know if they've been received. I'm not the officer in charge, so I wouldn't get a notification.
Thank you, nothing further.
On behalf of Mr. Denard.
Ashley, thank you for the $10 super chat. Very much appreciate that. And Grandma TCF, thank you for donating 5 memberships. Everybody's missing their target, but I appreciate everybody's efforts and thank you all for the support.
Mr. Denard was June of 2021.
I believe that's the last time I had an interaction with him, yes.
What was that interaction like?
I was driving an undercover police vehicle in the city of Pontiac on Kettering near the Newman apartment complex. And as I drove by a group of individuals, I saw Mr. Denard stand on the sidewalk. I recognized him and knew that he was wanted pursuant to a Sixth Circuit Court felony commitment warrant for weapons offenses. I set surveillance on that location. Ultimately, he went into an apartment and emerged. We converged and attempted to take him into custody when he fled inside an apartment. Ultimately, he did surrender himself. We took him into custody and lodged him in the Oakland County Jail. I was part of an apprehension. It wasn't a targeted team. I happened to see him while I was working, and then we made a plan over the radio and took him into custody.
You were there for the arrest on the apprehension at Fort Evelyn, right?
I was not there for the actual apprehension. I was just there after the fact.
You mentioned something about an empty gun case. Is it tell me about this.
It's like it'd be like a zipper gun case. It was empty. There's nothing in it. It's soft sided. It has a zipper. It's designed for a handgun to be transported or stored. But
anybody else live at Appalachian besides Mr. Denard?
I have no idea.
Do you find any newspaper work in his name?
I don't recall.
Did you find any identification that actually maybe like a driver's license that said Fort Appalachian for Mr. Denard?
I found his driver's license there, but I don't believe his address in the license was Fort Appalachian.
The gun case, did it have anything else? Well, you said it was empty, but did they have like foam or anything?
I mean, it was intact. There is foam in it, but it was empty. I mean, it's just like
Was it just?
Correct. It's like you buy it off the shelf at Dunham's.
Did you identify or take anything else besides the gun case from there?
I didn't take anything else. Detective Bader arrived on scene and completed that portion of it.
So basically, you were just you didn't have not to minimize it, but you didn't have much going on there.
I just assisted in the search.
And you found nothing really of no value towards shooting and else.
I didn't find any weapons or anything 9mm there. No.
Thank you.
Right.
Denard.
All right, you may step down. Thank you, Raj. Thank you.
Thank you, Rob.
Any other witnesses?
Yes, Your Honor, people call Tracy Swan.
Again, good morning, everybody. TCF Live. It's Friday. It's good to have all of you here. Thank you again, blanket thank you to everybody for their generosity today. Really appreciate it. We're going to continue with this hearing because we're invested. This is Judge Jeremy Darnell Bowie. Obviously, we're in a prelim exam here for some bad alleged crimes. There are things going on in other courts, and we'll get to them when appropriate. And it'll be good. So let's keep going.
Your truth, the whole truth, and nothing but truth.
I did.
All right, you may be seated.
Ms. Swan, will you please state all your full name for the record?
Tracy Swan, TRACYSWAN.
Ms. Swan, how are you employed?
I'm a parole agent with the Michigan Department of Corrections.
How long have you been a parole agent with the Michigan Department of Corrections?
20 years.
And are you familiar with William Harper?
I am.
How are you familiar with Mr. Harper?
I was assigned his parole agent when he was released from prison.
When was Mr. Harper released from prison?
March 25th, about 2025.
As Mr. Harper's parole agent, did you meet with him in person?
Yes, I did.
How many times have you met Mr. Harper in person?
I don't know the exact number of times, but I believe it was around 5 or 6.
And where would you meet with Mr. Harper?
I met with him at his home mostly and at the parole office.
Do you recall which home?
Yes, his residence at 117 Warwick Street in Pontiac.
Do you see Mr. Harper in the courtroom today?
Yes, I do.
Can you please point to him and describe an article of clothing or some other identifying feature?
He's sitting at the table there wearing an orange outfit.
Okay, is he, can you describe what color socks he's wearing?
White socks.
Your Honor, let the record reflect the witness identified, Mr. William Harper.
So noted.
Thank you. In late September 2025, did Detective Robert Bader contact you?
Yes, he did.
Why did he contact you?
He had a video that he wanted me to view to see if I could identify the subjects in the video.
Did you have an opportunity to review that video?
I did.
What did that video show?
It showed two individuals running through an apartment complex that I was familiar with. They were shooting a firearm and running in and out of an apartment complex, hiding behind bushes, reloading a firearm. And then at one point, I believe they got into a vehicle and left the scene.
Okay, so it sounds like you may have reviewed multiple videos. Is
I
that
did.
correct?
I did.
And in each of those videos that Detective Bader showed you, did you recognize anyone in those videos?
No, not initially.
Not initially. Did, as you're saying not initially, but at some point, did you later recognize an individual in those videos?
Yes, because of the quality of the video, what we did was we actually had still shots of those and made them into photos. And then I was able to clearly identify one of the individuals as Mr. Harper.
How many photos would you say that he reviewed?
I believe it was 3 or 4.
And were these photographs from the different CCTV videos that you also observed?
Yeah.
And in each one of those photographs, from each one of those videos, did you recognize someone in those videos?
Yes, ma'am.
Excuse me, you recognized someone, correct?
Yes, ma'am.
And who did you recognize?
Mr. Harper.
I have no further questions for this witness.
Cross on behalf of Mr. Harper Jr.
No questions, Your Honor.
Cross on behalf of Mr. Mercer.
No questions, Judge.
I'm sorry, I'm Mr. Evans.
There's no questions.
All right, you may step down. Thank you.
Your Honor, one more witness, and that's Detective Kyle Norris.
Judge, I have to ask them. Yes, go ahead.
All right, we can take a short recess.
Thank you.
Yeah. We come back at 11.
That'd be one. Thank you very much, Judge.
Okay, friends, it looks like we've gone mute. So let's do this. I'll keep an eye. We'll come back because, again, we're a little bit invested. But for now, let's go to Jefferson County. Say good morning to Judge Stevens.
I'm sorry. Say that again.
We should be able to work something out. I've spoken with Mike this morning with the prosecutor. I just need one more setting, sir.
This was a motion to revoke probation out there, right?
Yes, sir.
Well, we don't need an agreement. Really, do we? When can we do that? If I gave you some time.
Next time.
Couple of weeks.
Couple of weeks.
That's all.
Yeah. That's all.
All right, let me ask you, hold on, let me look and see if we got a fire we're having at 5. Yeah, everybody says that, but we had one on the last case.
I mean, sir.
Ms. Carmen?
Yeah.
There's a motion to revoke probation. You're on probation for aggravated robbery and it alleges that you committed an offense over 2 years ago.
Yeah. Well,
there was a good reason, I guess, that one stalled, huh? Because this was filed just in August of last year. But this states this occurred almost 2 years before that. What took so long?
Well, the offense was committed on December 16th of 23.
23.
They got indicted on September 24.
I know, but this didn't get filed until August of 25.
Yeah.
Just one of those that went slipped through the cracks, Judge.
Okay.
When he got caught, we got it. We got
Okay.
it filed.
I know, we got,
Actually
that's
goes back-
what happens when we're the 22nd largest county with the 16th highest crime rate. We're fighting fires everywhere.
this went back to 2016.
No, yeah, she's been on probation since
Yeah.
2016, but
Yes, sir. But we should, Your Honor, we should be able.
Here's what's going to happen. We said this for 2 weeks. Either there's an agreement or we have a hearing. I'll make the decision. Okay.
That's right.
All right. We got because this thing's
Thank you, Chair.
way too long. Okay. Thank you.
Yeah.
Rodney Cleveland. Uh-oh, there's a big sigh. There's a big sigh. He came in to sign. Brett was signed. That's not good. Taking a big breath. We're Rodney Cleveland? No, where's Mr.
He's in custody.
There's Mr. Cleveland.
Very different ethics.
Your Honor, on this one, we are still waiting on the new drug case. I'm not sure what's taking the lab so long. We have checked on it multiple times.
You're talking about this February 6th of a year ago?
Yeah,
Email to you if you want to get her.
it's my understanding that it's still coming according to the people that I've checked in with. I just don't know why it's taking so long.
Where's the problem? Because this is abnormal, and there he is sitting around languishing. He's in the twilight zone. We got to move forward one way or the other. I mean, this thing was filed in May, and we still don't have.
I believe we're waiting on the labs for the drugs. I'm not.
Can you find out for sure? It's kind of important because if there's a delay, I'd like to know from the lab why. Because this is too long.
Okay, I can speak to the lab. I know they
They got a lot.
Yeah.
But motions to revoke, we're in the twilight zone. Those are important.
Turnover over at the lab too, Jeff, so trying to meet people.
How long have you been in custody?
Judge, if possible, while we're trying to wait to get the labs back, is it possible to set a bond for Mr.
How am I going to do that with what's is alleged here?
I'm sorry?
How am I going to do that with?
Well, in the new cases, it's been over 90 days and they haven't indicted, so they're not ready on those. And then on the latter part, this is, if my memory concern is.
This is what happens.
This is a deferred.
They're going to ask, and the court's got to consider whether he should be now released. And we know what is happening. He's
got a job waiting for him, Judge. He will be in attendance.
He's alleged to be using synthetic marijuana. That's straight from hell. We all know that. Methamphetamines. Failing to provide verification of completing anger management that he was supposed to, not doing community service. I mean, goes on. There is something I am curious about. Allegations 2 and 3 allege the exact same things. How can that be? What's
Your Honor, I believe that it's.
What's the distinction between those two? They're both. He admitted to using illegal drugs, synthetic marijuana, to the police, and then illegally possessed synthetic marijuana on February 6th. Y'all carved out 2 allegations. What's the difference between?
I believe it's because of the use and the possession, Your Honor.
But
Condition 10 of this probation was do not use or possess. And according to this, he used and possessed.
It's alleging word for word almost the same thing. I was just trying to figure out what you're calling out of those. In both of those state, he possessed synthetic used and then possessed on the same day in violation of the same condition of action. Here's Here's the issue is you have in we're waiting on the drugs, but also there's an allegation he admitted to the police that to the Port Arthur police that he was using illegally synthetic marijuana. Let's just go on that.
Well, Judge,
What?
I'm going to have to object to going on that one because that would be part of any discovery on a new case. The state has not provided me any sort of anything to indicate that there was in fact a valid admission for this. This is simply someone pleading that he said he admitted to it. And I don't know that anyone in this courtroom can verify or testify to the fact that he said anything.
Well, can we?
That would be part of the new case. We don't have the new
2
case.
weeks. I'm gonna set this for a hearing on 2 weeks, okay? And getting whatever discovery we need, and if we can't get the results, we'll go on what we can, because this is language too long.
Can we have a bond in the middle?
No.
Judge?
No, sir. Willie Coward.
All right, let's change it up again. We're going to go to Florida, Wade Mercer, and his first appearances, which just happened a short time ago. So we will do that. FYI as well, that other court hearing that we were watching in Pontiac, they're still muted there. So I'm keeping an eye, and we're going to try to finish that, even if it cuts into our normal 4th hour.
At 8:30 a.m. And Corporal, good morning, sir. Have you had a chance to play your first appearance video? Can you hear me, Corporal?
Yes, sir. Good morning. Sorry, I had it muted. Yes, sir.
No
I'll show
problem.
the video.
Great. Ladies and gentlemen, at the jail, I'm Wade Mercer. I'm the county judge in Jackson County. We actually have 4 attorneys involved in the first appearance process today. We have Mr. John McDaniel, Assistant Public Defender at the jail, who'll be representing several of you. We have Mr. Mitchell, our prosecutor in the courtroom. And we have 2 private attorneys appearing remotely. Mr. Atkinson's on behalf of Mr. Olds, I believe. Is that right, Mr. Atkinson?
That's correct, Your Honor.
And then Mr. Miller has a plea immediately after first appearance. So we'll get to Mr. Miller in just a few minutes. So first we have State versus Henry Olds. Mr. Olds, good morning, sir. You're here because you've been accused of 1 count of lewd or lascivious molestation of a child under 16 years of age. Mr. Olds, I read the complaint. There is probable cause for the charge. Mr. Olds, I'm sure that Mr. Atkinson would like to be heard on this. I'm going to listen to Mr. Atkinson and listen to the state, and then we'll address your bond status. Mr. Atkinson, sir.
Your investigator Corbin with the Jackson County Sheriff's Department reached out to Mr. Olds about 2 weeks ago. Mr. Olds came to me, excuse me, Judge, and I've had pretty good constant contact with investigator Corbin. He called me yesterday, indicated that there was a warrant, and I informed Mr. Olds of that. And he turned himself in, Judge. So he absolutely is not a flight risk. He knew that this may be coming down the pike, for at least probably 2 weeks now. Judge, he is a lifelong resident of Jackson County, and he does have a job. He has family in the area. So, Judge, based on that, I'm asking that the court set him a reasonable bond so he can make bond and be released from jail.
Thank you, Mr. Atkinson. Mr. Mitchell, anything from the state?
We will acknowledge that I got in contact with Wes yesterday, and he did inform me that he did turn himself in. I guess the only condition we're really asking is that, given the seriousness of the charge, you have the condition of no unsupervised contact with minors.
Mr. Olds, I think you're entitled to a bond. The problem is, according to what I saw when this warrant was requested, you already are a registered sex offender prior to this allegation. This is something that happened many, many years ago. So that certainly doesn't help you. What does help you is what Mr. Atkinson pointed out, and that is that you turned yourself in. So I do appreciate that. That's going to affect the bond I set this morning. I had written down a tentative bond of $25,000. That was before I knew anything about you turning yourself in. In light of that, that does indicate you're not a flight risk. You still got the same criminal history. You still got the same allegation against you, and it's only an allegation. You haven't been convicted of anything in this case at this point. Your bond's going to be set at $15,000 cash or surety with the condition of no contact with the alleged victim. Mr. and no contact at all with the alleged victim. And due to the nature of the charges, no unsupervised contact with any minor. And the only people that can supervise that would be individuals who have authority to care for the child that you're around. They're present and they're aware of the charge, the current charges. So that's the only circumstance I need you having contact with the minors. I don't want you getting accused of anything else while this case is pending. We're going to give you a notice for your next court date. That would be
This one's still the 3rd, is that right?
February 3rd at 8:30. Now, if Mr. Axon files a notice of appearance, that court date may change. I'm not sure how Judge Garcia does that. Mr. Axon would know better than me, but otherwise it's going to be February 3rd at 8:30. Mr. Olds, I want to give you a chance to ask any questions, but what I really want to see if your attorney has anything else he wants to address, because I don't want you to say anything that's going to hurt yourself. Mr. Axon, anything else today, sir?
No, sir, Judge, and I kind of told Mr. Olds the range of the bond. Actually, we appreciate the bond that was set, but I have nothing further at this point in time.
Mr. Mitchell, anything?
Nothing else from the state at this time.
Mr. Olds, wish you the best, sir.
Okay, sir.
All right, Judge Bowie in Pontiac is back up and running, so I'm going to take us there. We'll come back to Wade Mercer later if we have time, but we're invested in this hearing, and I don't want to leave it paused for too long because Judge Bowie generally deletes his stuff, and I'd hate to miss out on the end of this. So let's go back to Pontiac.
This court be the truth, the whole truth, and nothing but truth. Ready? All right, you may be seen. Thank you.
Detective, can you please spell your legal name for the record?
Kyle Mounts, KYLEMOUNTZ.
Investigation involving shooting at the Newman Court of Evidence on September 18, 2025.
Yes.
Now, at some point, did you contact Avis?
Yes, I did.
Why did you contact Avis?
Avis Rental Car Company was identified as being the registered owner of the victim vehicle, the Jeep Grand Cherokee.
And you spoke with a representative from Avis, correct?
Correct.
What information regarding the renter of that Jeep did you get?
The full name of the renter,
And what is the full name of the renter?
Jamari A. Burns.
Did you run the name Mario Burns through Lean?
Yes, I did.
Did you get a registered address?
Yes, I did.
What was the registered address?
598 Palmer, in the city of Pontiac.
And you eventually recovered the Jeep that was involved in the shooting on September 18th, correct?
Correct.
And where was that Jeep located?
It was located, it was in front of the area 638 Palmer. It's all in the Lancaster apartment complex.
That is close to Jamari Burns, correct?
It's within a couple blocks, yes.
What, if anything, did you observe about the Jeep?
I observed that it had apparent damage to it that appeared to be from projectiles such as bullets.
How many bullet holes were there in the vehicle?
4.
Where were those bullet holes located?
There was one in the front bumper about center. There was another one towards the lower of the windshield, and in the center of the windshield. And then there was 2 to the driver.
And the search warrant, the execution of a search warrant, 117 Warwick.
Yes,
What kind of dwelling is 117 Warwick?
it's a single-story ranch style home.
And who is associated with 117 Warwick?
William Harper Jr.
Who was home when the search warrant was executed?
It was William Harper Sr., 2 of his adult daughters, and then 2 minor. I think it was a teenager, then a younger child.
And did you locate any clothing inside the home that was determined to be of evidentiary value?
Yes,
What did you locate?
a black pair of Timberland boots.
And why did those black pair of Timberland boots appear to be of evidentiary value?
From screenshot images from the Newman apartment complex incident from the shooting. It appeared that William Harper was wearing a pair of boots that were consistent with black Timberlands.
No further questions for this witness.
All right, cross on behalf of Mr. Harper.
And your primary role then for this investigation was supervising the search at the Warwick address, correct?
For that date, that was something I did, yes.
Okay, but you didn't observe the shooting on September 18th, did you?
I've seen some of the footage, but nothing in the entirety or like be able to analyze it. That was not my role.
Um, So at 1117 Warwick, this is not the address where the Taurus handgun was found, correct?
Correct.
And at this address, the firearms that you found were locked under William Harper Sr.'s bed, is that correct?
Correct.
And that safe was opened by William Sr. with the key from his keychain, is that correct?
That's correct.
And when Mr. Harper Jr. was arrested, he did not have on his possession a key to that safe, did he?
I don't know. I wasn't with him when he got arrested.
And from your knowledge now in the case, do you have any reason to believe that Mr. Harper Jr. had a key to that gun safe?
I have no knowledge of that.
Do you have any evidence that would suggest that William Harper Jr. purchased either of the guns found at the Warwick address?
No, I do not.
And you collected DNA swabs from, it was a Glock and a Ruger that were found there?
Yes.
Did you collect DNA from those?
Yes, I did.
And there's no, at this point, there's nothing connecting as far as DNA for William Harper Jr. to those weapons, is that correct?
I don't have that answer. Not as being the officer in charge, I'm not aware of any lab tests or results that were done.
Understood. And then with respect to the boots, were those tested for gunshot residue?
I don't have that answer there. I don't know.
Thank you, nothing further.
All right, I'm the Mr. Lenard.
No questions. Thank you, Judge.
All right, you leave it.
No, Your Honor.
All right, you may step back up.
Thank you, Your Honor.
All right, you have somebody have?
No, Your Honor.
anything?
No, wait.
Witnesses on behalf of Mr. Harper Jr.,
No, Your Honor.
on behalf of Mr. Leonard,
No, Judge.
a motion to bind over, you may need it.
Your Honor, at this time, the people move to bind this case over as charged as it concerns both defendants, Mr. William Harper and Mr. Alante Denard. Really, this is about the AWIM itself.
You're okay, she's not done.
Yes, he should be okay. Thank you, Judge.
Sorry. Really, this case is about the AOM and then the gun offenses really follow along. I think you can discern from all of the available videos that we saw that there were two individuals that appear to be both Alante Denard and William Harper. They are in the Newman Court apartment complex. We can see from those videos that are pieced together that two individuals, they have an interaction with Jamari Burns. They separate from each other. The shooters in that case get into the back of a Suburban and the front passenger seat, and they drive away. Jamari Burns also gets in a Jeep. He drives away. We have on video, we can see two individuals that appear to be both Alante Denard and William Harper. They get out of that vehicle. They walk north in the direction of where that Jeep is coming from that's occupied Jamari Burns. And then you can see from multiple angles that there were approximately 10 shots fired from two separate guns. We can see muzzle flashes from two separate guns, and we can hear about 10 shots being fired. I think as it concerns intent, at least in this case, you can easily discern that firing 10 bullet shots is enough for assault with intent to murder. We also heard from Detective Mounts that he later had an opportunity to observe the Jeep itself and saw multiple bullet holes to that Jeep. So then really the question is, are those shooters in fact Alante Denard and William Harper? And I would argue that in fact that they are, that there's multiple pieces of evidence that demonstrate that those are the two individuals that were in that shooting. We have the testimony of Detective Nate Rogers that he testified that he observed multiple videos, the CCTV videos, and he recognized he recognized Mr. Denard, having had previous interactions in the Newmanport Apartments where he was on active duty. We also have the testimony from Mr. Harper's parole agent, Ms. Swan, who testified that she also had an opportunity to review all of the CCTV videos, and she determined that it was in fact Mr. Harper that was in those videos. She herself said that she saw Mr. Harper when she watched the shooting take place, as well as when they were running throughout the Newmanport Apartments. We also have the testimony from Detective Bader, who he pieced those videos together. He really put a timeline down as from when the shooting occurred to really much that hour that preceded that. And from those videos, we can see that these two individuals were together the entire time. From their interaction with Mr. Burns all the way through the shooting, and then when they're running throughout the Newmanport Apartments, and then eventually they get back into that same Suburban and they drive away. There was also a firearm that was collected from Mr. Harper's home. And we can see from the direct comparison in this case that there were 10 shell casings that were recovered. And we know that at least 8 of the 9 shell casings were recovered, matched that Taurus firearm that was collected. So we know that he at least was involved in the shooting, and then we also can identify Mr. Denard as one. He also admitted that he himself was present with Mr. Harper that day, and that he knows Mr. Harper, and identified himself as being adjacent to another individual who has been identified as Mr. Harper. So I think, Your Honor, if you look at all of this evidence, understanding that we don't have a victim here today. However, I don't need a victim for assault with intent to murder. We can clearly discern that there was an assault to murder Jamari Burns based on the number of gunshots that were fired and the manner in which those gunshots were fired, as well as that initial interaction between them where there was some sort of argument that took place. And then after the AWIN, there are those accompanying firearm-related charges. So as it concerns Mr. Harper, there's that felony firearm third. I did provide the court a certified copy of conviction for his prior conviction. That is the predicate felony for those, that's for the felony possession, Your Honor. But this is a felony firearm third offense. We know that he had a firearm. For the felony possession from September 18th, that concerns the shooting. But for the felony firearm that concerns September 30th, 2025, that is because the firearm was recovered from Mr. Harper's bedroom that was in that basement at 263 West Fairmont. And then as it concerns Mr. Denard, I did provide a certified copy of conviction for that felony possession of a firearm. There are also CTW charges. They both were clearly in possession of a firearm, and they were putting them in their clothing in order to conceal them. Based on a probable cause standard, I think, Your Honor, there is enough evidence to find this case over as charged. Thank you.
On behalf of Mr. Harper Jr.
Thank you. Your Honor, at this stage of the prosecution bears the burden of showing probable cause that a felony was committed and that the defendants committed that. For assault with intent to murder specifically, the prosecution needs to prove that there was an assault with a specific intent to murder, and I do not believe that that's been met here. And even viewing the evidence in the most favorable light to the prosecution, mere suspicion or speculation is not enough to establish the intent. And it's not enough that, the defendant's shooting. AWIM requires, as I mentioned, the specific intent to murder, not merely the intent to assault or terrify or recklessly endanger. And it can't be presumed just because guns were used in this matter. It's whether it's reasonably supported and can be inferred from the evidence. And here, we don't have a complaining witness, so the evidence is showing that there were shots fired at a vehicle. And based on that and the fact that the driver of the vehicle had exited and that the shots went at the vehicle and not at the individual, that would be more of a lesser offense, that they were seeking to frighten the individual, not to attempt to murder him. So I would ask the court from this record that the court consider a lesser offense such as felonious assault, discharge of a firearm from a motor vehicle, reckless and wanton use of a firearm. And I would ask that the court find that there is not probable cause with respect to the AWIM, and then the lesser offenses, of course, fall in line with that. Thank you.
We have Mr. Leonard.
Thank you, Judge. And I don't go with Sister Council's statements with regards to this. Most importantly, we do not have an individual that was here to indicate that they were in fear for their life, that they thought they were going to be killed, that they believed that they were assault with intent to murder. We do not have that. What we have is a situation where a gentleman stops a Jeep in the middle of the road where two people are walking, gets out of the Jeep, and then you hear shots fired. As Sister Council was indicating, this is a lesser case. It's not an assault. There hasn't been placed on the record any inferences of the actual intent to murder. What has been placed is guesswork for the court to make up whether there is an assault or whether there's an intent. But this guesswork is not enough at this probable cause stage, Judge. The manner of the shots fired, the scope of the situation, the individual that allegedly has been shot at is not here. Not here to say to this court or to any of us what transpired then. The videos are what the videos are, but they don't speak for this situation. And what we have is again, a Jeep pulls up, guy gets out, and then shots fired. This is at most FA, HPH. And again, as the indication on that Jeep, the shots hit the Jeep, there's nothing that close together. There's no trees, there's no markings. With that, Your Honor, we're asking you to deny bind over on the assault intent to murder. Thank you.
Response.
Your Honor, I'm just going to highlight just the elements for the court for assault with intent to murder. There are three elements that need to be proven. The defendant trying to physically injure another person, and when the defendant committed the assault, he had the ability to cause an injury, or at least believe that he had the ability. And third, the defendant intended to kill the person. Nowhere within those elements does it state that the people have to prove how the victim felt in this case, what the victim thought that the intentions were of the defendants in this case. And I would also just argue that if anything, the fact that the victim in this case got out of the vehicle further demonstrates an assault with intent to murder, because the shooters, the defendants in this case, were out of the vehicle and had a clearer shot of who they were aiming at. They weren't just indiscriminately shooting at a car. They had a physical person and a physical body outside of the vehicle when they were shooting. Thank you.
I just want to see the video of the Jeep again. I was kind of hoping we had to put the court back.
Yes, Your Honor, absolutely. Sorry. No, I was premature in putting this away. I'm so sorry.
Just want to see the Jeep video.
Yeah. I have it. I just need to start. Referring to the first video Would that be,
Yes, I believe it's, is it exhibit 2? Might be exhibit 1 or 2. Yeah.
would you like to review our videos?
Gee, it's the Suburban's on the other side of that.
That is correct, Your
Yeah,
Honor.
you see the Suburban.
This is the video of the Suburban, Your Honor.
So.
Okay, friends, while Judge reviews this video, Barbara just put in the chat. What?
All right.
Hang tight.
So we'll start with the guns. Start with Mr. Harper Jr. I mean, that's a slam dunk right there. I mean, they found the gun at the work address. He stays at the work address. It was found in the basement. There was information in the bin with his name on it. He's a felon. So even if he's walked on everything else, he still is a prohibited person in possession of firearm. That's felony firearm third is a mandatory 10 years. So I think he can be bound up on that. There's not much argument need to be made. I think the record is unequivocally clear on that. As far as the carrying concealed weapons, as far as the September 18th date, I noticed from both arguments from the defense, they are basically saying the defendants had a gun, the defendants fired a shot, but they never said, any of them, that in reviewing the evidence, that Mr. Burns fired a shot first at them. And so there's no self-defense claim there. And so as far as the attempted murder, it is true you don't need to complain in an attempted murder case. That is the instructions we give jurors at jury trial. So no one needs to come in and say someone tried to kill me. Circumstantial evidence, which all of this is enough to convict as if it was direct evidence, or it can convict with circumstantial combined with direct evidence. So this is clearly a circumstantial evidence case without Mr. Burns' testimony, but I think the videos are pretty clear. And then two, you have Agent Swan, who has nothing to do with this outside of identification of Mr. Harper Jr. That is his parole agent. And Detective Bader sent the video and some photos to Agent Swan and said, "Is this your probationer? I mean, your parolee, I'm sorry." She's like, "Yeah, that's him." You know, so she confirmed that he was there. We saw both individuals in the back of Newman So you have the back of Newman's, and in between Newman's, there's like this huge drop off where the railroad tracks are. So behind Newman, you can see two people. You can clearly hear two people racking guns. They're both wearing white T-shirts. And then they're moving about the back of that Newman court from north to south, and they move eventually south outside of the camera. So I believe there were both weapons there. You can see them jumping out of the white Chevy Suburban. Shots are fired toward the direction of the Jeep. Also, yeah, the prohibited person, Mr. Harper's a felon, should not have had a weapon. So both of the prohibited persons will be bound over with the felony firearm third. Same with Mr. Denard. He was not allowed to have a weapon. He was a felon. So that'll carry over along with the felony firearm second, which is mandatory 5. The carry and conceals will go. They both were concealing weapons inside the white Chevy Suburban. And also, 10 shots to the driver's side of the vehicle. I believe she said it was the front bumper. There was a shot to the windshield, and there's 2 shots to the doors. I don't know what's more clear. You're trying to kill somebody. You're not shooting to wound, you're shooting to kill. And so I just think there's enough evidence to send it over to judge or jury to determine whether they're guilty or not. But I believe the prosecution met their burden of the probable cause standard as charged here at the 50th District Court. And so it will be sent over to the 6th Circuit Court as charged on both individuals. Shots at the windshield, and I don't even think Mr. Burns moved far. I think he just got out the car. The next thing you know, his shots started ringing out. So they're bound over as charged.
Thank you, Judge.
Arraignment date will be 7 to 10 days from today. We'll continue the bonds. We're all set.
Thank you.